Right, good morning and welcome to the District of Columbia Court of Appeals. You have the distinction of being our opening arguments for the 2025-2026 term. We have three cases today. I am Chief Judge Anna Blackburn-Rigsby, and I'm joined by Associate Judge Roy McLeese and Senior Judge Phyllis Thompson. Our first case is Daniel Greene versus United States. Counsel, are you ready to proceed?
Thank you, Your Honor. Timothy Cohn representing Daniel Greene. I'd like to save 4 minutes for rebuttal. On the procedural default question, I acknowledge that I failed to bring to this court's attention until the recent 28K the authorities on that. I would move on past that point and go to the merits unless this court has questions about that.
Well, I guess my one question is that late filing of your 28K, does that constitute a full waiver of the issues that you wanted to raise? Or do you just prefer not to address the waiver and go straight to the merits?
No, Your Honor, it's not a waiver. I've looked at this court's waiver cases. When a matter is beyond debate like this, when an appeal is pending, this court has discretion just to simply resolve the issue based on the law. And I'd add that the number one reason for the appellate waiver rule is to give opposing counsel an opportunity to respond, and we've seen their response yesterday, and their response doesn't contradict the notion that the finality of this court's decisions become final when the mandate is issued. There's nothing I can do to change that rule. It's beyond debate. And again, I acknowledge my mistake.
Is there a case that you think is more on point than the Clark case that you cite in your 28K letter? In Clark, the government did not object that the 23-110 was procedurally barred because of the timing. And so it seems to me that the court did not really in Clark sort of get to the issue of whether or not a 23-110 motion filed a few days before the mandate issued, meaning that the court did not have the opportunity during the direct appeal to sort of grapple with the issues raised, no opportunity to stay the motion, was not really raised. The issue was not really raised. Is there a case that gets to the point more directly or more clearly? I mean, do we have a case that says as long as you get that 23-110 filed, you know, before midnight on the day before the mandate issues, you're good?
Judge, I think there's no holding on that. Your description of Clark is correct. There was an administrative order issued by this court that said, you mentioned the stay proceeding, that's no longer the proceeding. But I don't think we need a holding. It's a matter of this court's discretion. And when issues like this are beyond debate, then there's really no purpose served in finding a waiver in this situation. The court can just reach the issue, and the appeal was still pending when the 23-110 was filed. So if I may turn to the merits, the deficiency in the trial court's decision here are numerous. One is that it treated the 23-110 as presenting, its words, not mine, the same issues as the direct appeal. And that's, in fact, not what the 23-110 did. It said in its very first page that the combined effect, again, not my words, counsel's words in the trial court, the combined effect of eliciting testimony that her own client was a dangerous person and wanted to get rid of a witness, which is highly prejudicial, combined with the mistaken, and again, not my word, now the trial court's word, that if the announced prosecution witness was going to refuse to testify, he had to do that in front of the jury, when in fact this court has understandably said, no, we tried to avoid having witnesses refuse to testify in front of the jury. The point being that the combined effect of these two errors by counsel, and they are naturally combined because both convey precisely the same prejudicial notion that the defendant should be convicted of aiding and abetting because he's a dangerous person.
Can I
And
ask you why you think the second of those problems precisely conveys the idea that your client was dangerous? It seems to me that it's kind of, a jury might have a variety of reasons if it were inclined to speculate as to why Mr. Williams wasn't testifying. Lay jurors probably understand that folks can't be made to incriminate themselves ordinarily. They wouldn't have known that there was a plea agreement and that Mr. Williams had waived his Fifth Amendment rights. So it seems like if the jury was inclined to speculate, it might have had other reasons.
well, in opening argument, but the Martin case addresses your concern, Judge, but the prosecutor in opening argument, that's worth reading in response to your question, says the defendant was with two other people. Their names are Sean Williams, the witness who eventually refused to testify, and Alicia Whitted. You are going to hear both Sean Williams and Alicia Whitted, and they're going to come into this courtroom and they're going to sit on the witness stand right here, and they're going to tell you what they did on July 31st. And they're going to tell you what Daniel Greene did because he is the third person who was with him. And then directly answering your question, Judge McLeese, both Sean Williams and Alicia Whitted have pled guilty in connection with their roles in this offense. They're going to come into this courtroom in their prison garb with their handcuffs off. They're going to tell you what they did and why they're sitting here today. And the prosecutor concludes, most important, they're also going to tell you what Daniel Greene did, what the defendant did. And so this is a situation where, in view of that announcement, the speculation of the jury is inferable.
Counsel, my recollection is that at some point the prosecutor told the jury, you may or may not hear from Mr. Williams. Didn't he say that at some point?
I don't recall.
I made a note about that. All right.
I mentioned earlier aiding and abetting. And I think the fact that this was an aiding and abetting case, that my client was just in the back of a car and we're now trying to infer his state of mind, and we're trying to convict him not based on his actions, not even actually really based on his words, is something that the trial.
Why do you say not on his words? I thought that.
I may have gone, okay, he had some words that he allegedly said, but it wasn't by words. I mean, do we have communications with the carjacker? Hey, let's go do a carjacking. No.
I thought there was testimony both from Ms.
Whitted.
Whitted, thank you. The W's are getting me confused here. Ms. Whitted and from the complainant in the carjacking that someone in the car, inferentially your client, was directing the actual actor.
Respectfully, Judge, that's not my recollection of the case. And to continue with my point, nowhere in the trial court's opinion, which by the way was a 6-page opinion, 3 of which were about procedural defaults. So as a colleague of mine put it, the trial judge box checked the merits. It's very, very brief and never mentions that this is an aiding and abetting case. And so, which is, to my mind, highly significant, because that's why the prosecutor in an opening argument said what I just read to the court. It said, you're going to have the actual carjacker say, this guy was aiding and abetting me. And so, and the court says, well, there was no prejudice. We had cell phone calls showing, we had cell phone records showing that the carjacker was speaking to the defendant. But we need to know to convict this person what was said in those cell phone calls. We need some evidence that this defendant was aiding and abetting a crime.
In part of your argument, counsel, you expressed a great deal of concern about the witness, Ms. Celine's testimony. How important was it that she was allowed to testify or not?
The mother of, yeah. It's not that well, actually, she was not a key witness. There was no reason for defense counsel to violate the cardinal rule of trial lawyers, which is never ask a question on cross-examination to which you don't know the answer. And so, she asks questions that eventually the prosecutor follows up on. And yeah, Williams told me that the defendant wanted to get rid of my daughter. I mean, this is the kind of, having read my fair share of the cases from this court, this is the kind of testimony which does show is highly prejudicial.
Now, there were two different curative instructions given by the trial court to try to address some of the errors that you raised. Why aren't those curative instructions enough to address the concerns of error that you raised?
For two reasons, Judge. The first one is, as this court's, in some cases, this court says the curative instruction was sufficient. In other cases, it says no, the curative instruction was not sufficient. The difference between the two tends to be that when it's an isolated incident where the trial court immediately, not my word, this court's words, immediately gives a curative instruction. You just heard this, please disregard it. Isolated situation. Then, yes, the curative instruction can be sufficient. But there are other cases where the prejudice, such as the prejudice here, the cases that are in my brief, where the defendant was allowed to say, yeah, I said, let's get rid of this person. That's highly, highly prejudicial, and then coupled with the refusal to testify, which, for the reasons I gave Judge
What
Please.
was the problem with the two curative instructions here? Specific.
One of them was, I mentioned the immediate aspect, the refusal to testify of the prosecution witness that was just announced in opening statement. That curative instruction only occurred in the following day in the final jury instructions.
So the timing of both of the
That's right.
instructions was the problem, not the content of the specific instruction.
Well, the content, and on timing, just to stay with that, similarly with the first error, Judge, the allowing the witness to it was only the following day that the judge gave an instruction. The words, I'll have to take another look, Judge. They were B minus.
Well, I don't recall in your brief you criticizing the content of those instructions, but do you have, if you're giving him a B minus, is that a concern you raised in your brief that they could have been better worded, or?
That is not in my brief. I
And-
was just asked, I'm giving mine.
Fair enough, but why do you downgrade the instructions? The one after the relating to Ms. Whitted's testimony, the mother of Ms. Whitted, seemed, if anything, quite strong. It said not only disregarded, but also said the statements were without basis. Why is it you're downgrading them from? I know you downgrade them for delay. I get that, but otherwise, in terms of their wording, what did you think
No,
could have been done better?
You're right, Judge. I did not raise that in the brief. I think the point that is made in the brief is we're dealing here with the kind of inflammatory comment, deeply prejudicial comment, that a day later, after it's had time to sink into the jury's psyche, that, oh, this defendant is actually someone who wants to get rid of witnesses. And then coupled with later, well, I could see this witness is refusing to testify. So we're dealing here with the kind of deeply prejudicial comment that even words disregard are just simply not, as this court has recognized in a number of cases.
You know,
not-
counsel, I apologize because I told you that I made a note about the prosecutor saying that Williams might or might not testify. That was actually defense counsel who said that. So it's a different point. Defense counsel actually said in opening, you may or may not hear from Mr. Williams. He might not testify.
Thank you.
But what I wanted to ask you about that is, do you think there's any significance to the fact that when Williams refused to testify before the jury, he refused even as to pretty innocuous questions? He wouldn't even answer, what is your name? How old are you? So to the extent that the jury was inclined to speculate that, gosh, he must be refusing because he's afraid of the defendant, I don't think they could have said that with respect to his refusal as to those questions. Does that change the calculus at all, in your view?
Well, I guess I have to disagree respectfully, Judge. When someone is refusing to answer questions, that's going to raise inferences. I mean, I hope I'm not being too light about this, but if I were refusing to answer your questions right now,
Well, I dare say the situation would be quite
fair
different.
enough. But
Right, right.
so I don't think that diminishes, particularly as I mentioned a moment ago, because we already have testimony that the defendant supposedly wanted to get rid of one witness. So we have a basis for the jury to infer, well, he's not answering any questions because he's really scared of this defendant. And we don't want aiding and abetting liability to turn on the jury's speculation about whether that this was a very dangerous person. We want them to find facts. We want them to look at the facts and to say, you know, yes, there's sufficient evidence to convict. We don't have a reasonable doubt.
Yeah, you know, I have to agree with Judge McLeese. The reference to there was no basis for that testimony was almost telling the jury that Selenia Whitted lied in what she said. I've never seen such a strong instruction. Have you?
Yeah, but Judge, that I think I do address that in the brief, is that the judge tells them there's no basis, but they've heard the witness testify. A mother testifying about her daughter, there's no basis for what I'm saying about my daughter. The judge can say no basis as much as he wants. The jury has seen the mother testify and heard.
This is a judge who repeatedly said to the jury when there were objections during the closing arguments, said to the jury, your recollection controls. You know, this is just argument by counsel. But in this instruction, the court tells the jury there was no basis for that testimony. It's, to me, it was strikingly different and kind of above and beyond, frankly. It wasn't just a disregard the testimony. It was there was no basis for that testimony, as if the court was saying to the jury, Ms. Whitted lied. She made that up.
No, he didn't say that, Judge.
Not
Counsel-
quite.
Counsel, do you want to reserve the rest of your time for rebuttal?
Please, yes.
Sorry.
Thank you.
Good morning, and may it please the court. Amanda Claire Hoover for the United States. The trial court did not abuse its discretion in denying the 23-110 motion for 3 reasons. First, Greene procedurally defaulted his motion by not raising it during the pendency of the direct appeal. Second, Greene fails to show that his trial counsel's actions were deficient under the standard in Strickland. And third, Greene fails to show Strickland prejudice.
Can I
Name-
ask about the procedural default? Why was it a default if it technically came in under the deadline before the mandate was issued?
So I will agree with my friend on the other side that this issue has been waived. It's been doubly waived, in fact, by not raising it below and not raising it on appeal. But if this court wants to consider the merits of it, it's not actually clear that that he did not procedurally default this. The language in Shepard specifically requires 2 things: filing it during the pendency of the direct appeal and moving to stay the mandate. That's the language that the trial court cites when it rejects his motion as procedurally defaulted. And so that's why, in this case, this court should particularly find waiver.
Can I ask you about how that language operates in light of the fact that since the time of Shepard, this court shifted around from a system where the presumption was that the direct appeal would be stayed during the pendency of the litigation of the 23-110 over to a system, I think we announced it by way of an administrative order, over to a system where we didn't do that. So why would that component of Shepard be still viewed as operational? It seems to me that would be kind of nonsensical if we've announced by administrative order we're not structuring things that way.
So the language in Shepard still holds, and this court has not overruled Shepard. And I don't believe that this is the appropriate vehicle by which the court should overrule or change the language of Shepard, because this has been doubly waived. This is a complicated issue, and the government does not believe that a case in which counsel waives this issue twice by not raising it below and not raising it when the trial court expressly rejected his motion on this basis, that there has been sufficient briefing on the question of when the direct appeal concludes and whether a stay is required.
About your idea that it was doubly waived, I'm a little unsure about that, about how things happened in the trial court. My recollection is that although the United States made a procedural default argument in the trial court, it was a different one about the idea that there had been an earlier pro se filing and this was abusive or successive. And the United States didn't make a Shepard type default argument. And so it was the trial court who sort of maybe misunderstood the United States's procedural default argument and relied on it. So how could there have been a waiver or forfeiture of this point in the trial court by Mr. Greene's counsel? I'm not sure I quite follow that.
So in the government's opposition before the trial court, the government cited several different procedural defaults. It cited the Shepard bar. It also cited the second and successive bar and the abuse of the writ. But even
I just want to make, I may have missed that. Do you have a specific place where you can point me to?
I believe the government cites it in the standard of review. It speaks to specifically the Shepard bar.
And then argues that there was a violation of, there was a procedural default in virtue of failure to comply with Shepard? Because I definitely missed that.
I'm not sure that the argument is explicitly stated in the argument section that there was a Shepard bar. The government does state it in its standard review. It provides that Shepard analysis.
Provides that Shepard analysis or just indicates that Shepard is a relevant principle?
It cites from this specific language in Shepard.
Understood, but it's a little, it seems to me a somewhat tough argument to say that there was a waiver or forfeiture of this point in the trial court if the United States didn't actually expressly make the argument and instead cited a case upon which you could try to predicate the argument, but then didn't. So that I'm a little unsure about that.
So even if this court doesn't want to find a waiver in the trial court, there was a clear waiver in the appellate proceedings, because the basis by which the trial court rejected this as procedurally defaulted was that Shepard bar. The trial court said, it does not appear that a request to stay the direct appeal so that a 23-110 motion could be filed was made. That procedure has been required since Shepard. That was the express basis for the procedural default, and that's not something that appellant challenged in either its opening brief or in its reply
And
brief.
do you agree?
And does that
we have-
make, I'm sorry, does it make it a waiver or forfeiture?
I
And does
believe
it matter?
It makes it a waiver before this appellate court because they didn't raise that in the opening brief or in the reply
And
brief.
do you agree that we have discretionary authority to consider it otherwise, assuming there's no procedural unfairness?
I do believe that this court has discretion to consider this. I would note again that this is a complicated issue, and this is not sort of the case in which you should reach as a holding whether the Shepard bar still applies. This court most easily can reject or can decide this case based on the lack of prejudice.
One further question about at least on my part, on the procedural default piece of it, with respect to procedural fairness. Given the possibility that the court might choose to exercise its discretion to consider the issue, although belatedly raised, as a matter of procedural fairness, with the United States like an opportunity to file, because it definitely was late breaking relative to argument, with the United States like an opportunity to file something to address the merits. I mean, the United States had an opportunity in the response to the 28K letter to make some of the substantive points you've made for the first time here today, but the time was very short. Understood. So the question is, if the court is otherwise inclined to possibly consider that question, with the United States like an opportunity to file a post-argument brief addressing the issue?
So the government would be happy to file supplemental briefing with regard to the procedural default issue if the court likes that. As I believe Judge Thompson mentioned, the cases Clark and Richardson that appellant does cite in that 28K letter do not clearly seem to say that, you know, as long as a 23-110 motion is filed before the mandate issues, that is properly preserved. Those cases are specifically note that the government had failed to raise a timeliness issue in those cases, and so the court was not finding a procedural default. So we would.
And why is it that this case would not be a good vehicle for resolving the issue?
So precisely because it has been waived and briefed so late, or not briefed at all, because this was raised only in a 28K letter, and the government only had an opportunity to sort of point out that this was waived, but not to fully expand on the history of the Shepard bar, the rationale for the Shepard bar, and whether it still applies, that kind of thing. The government believes that this is not an appropriate basis or appropriate vehicle to address that. But if I could turn to the merits of the cause and or of the deficiency and prejudice analysis, this court can easily resolve this case based on the lack of prejudice. This court, in a panel that I believe Judge Thompson was on, has already addressed the lack of prejudice in this case. And that on the direct appeal, in the context of whether a denial of mistrial was appropriate, the court already analyzed the impact of both of these alleged errors and determined that they were minimal in the context of the full trial, that the curative instructions were sufficient and very clear, and that the evidence against Mr. Greene was substantial. This court has already considered the full weight of the evidence and determined that there is not a likelihood that these particular errors would have resulted in a different outcome at trial. It would be hard to square the district court or the direct appeal panel's decision in the prior case with a conclusion that there was Strickland prejudice here, namely that there is a reasonable probability that an outcome of the trial would have been different.
Now, there was no hearing on the 23-110 motion.
That's
And
correct.
I wonder what your view is on that. I mean, here, there was an opportunity, if a 23-110 hearing had been held, to probe the testimony further. And it's usually in cases where there's some dispute about the testimony, where we have said in the past that a 23-110 hearing is advisable.
A hearing was not necessary here for the third reason that this court has outlined in its case law, specifically that the allegations would merit no relief, even if true. Even if there were a deficiency that were proven during this hearing, this court has already determined that there was no prejudice in this case, specifically that the weight of the evidence against Mr. Greene was so substantial that it's not likely that there would have been a different outcome.
Can I ask you why you say that? The memorandum of opinion and judgment with respect to the refusal to testify of Mr. Williams in front of the jury said twice that it wasn't reaching that claim. So it didn't then assess the prejudice that would follow from it, treated as sort of invited error and said it's just off the books. It's true that then after the second time the court said that, it noted on an issue that it said it wasn't reaching, that there was a clear and thorough curative instruction, excuse me, that mitigated the harm. But that seems a fair bit distant from a determination on an issue that the court was deciding that there had been no prejudice of a kind that would warrant relief under Strickland if such an issue were raised.
My reading of the direct appeal decision is first that the court was making the determination that this refusal to testify argument was waived by trial counsel. But again, in the direct appeal, appellate counsel made the same argument that my friend on the other side is making now, which is that the combined effect of Selenia's testimony and the refusal to testify should have resulted in a mistrial. That's the same argument that trial counsel made below and that the trial court decided was not, did not merit a mistrial. Because of that, this court has already considered the combined effect.
You're still missing, I'm still not quite with you all the way. I get your point that if you think that the plain error prejudice standard is roughly similar to the Strickland standard, I could get the idea that if we had responded to the argument that was made in the direct appeal, which is the mistrial, the denial of a mistrial related to the refusal to testify and the damaging testimony elicited from Ms. Whitted together, were so prejudicial as to require a mistrial. And if we'd said, some of that may be defaulted or whatever, but we just don't think that, that's required. There'd still be the question of exactly how that relates to Strickland prejudice, but you'd be closer. But it is just not what the court did. What the court said right after identifying that as the argument that was being made is we're not addressing half of that argument. Half of that argument is prejudice that we're not considering. Then again, there's the statement that is at least somewhat helpful to you that says we note that there was a somewhat mitigating cautionary instruction. It just seems like it's not as dispositive of the issues in this case as you're arguing.
So the direct appeal decision on the issue specifically of Williams' refusal to testify said that there was a clear and thorough curative instruction, thereby mitigating any harm. And I would posit that there actually, because of the questions that you all raised with regard to appellant, was actually very little harm from this testimony to begin with. It's not clear that Williams's refusal to testify, where he did not actually plead the fifth, and he did not refuse to answer any questions with regard to Mr. Greene, even would have the harm that appellant sort of proposes that it would have. Mr. Williams got on the stand and he refused to answer questions such as his name, his age, and whether he was sitting in a courtroom to testify. After stating literally nothing in response to each of those questions, he was quickly ushered off the stand and a cautionary instruction was given. It's not clear that any inference with regard to Mr. Greene's guilt can be inferred from Mr. Williams refusing to testify at all.
What about your opponent's argument that if you put that refusal in the context of what the prosecutor promised in opening, it may not be an inference of fear, but at a minimum, it would be an inference that, the prosecutor promised that Mr. Williams was going to get on the stand and had pleaded guilty himself. That by itself helpful information to the government in the sense that it's corroborative of the government's theory of the case. And then also that he's going to come in and say what Mr. Greene did, which again, the jury would understand in the government's view is just going to inculpate Mr. Greene. So there were promises made about what his testimony was going to be, and then his refusal to testify. If it's not a fear inference, it seems to me it's damaging in other possible ways.
I have a couple responses to that, Your Honor. First, the trial court gave the instruction, as it always does, that opening statements are not evidence in the case. And it's unlikely that a statement just that Sean Williams was going to get on the stand and testify and that he pled guilty, would have any weight given that Alicia Whitted testified over the course of 2 days and directly implicated Sean Williams and Daniel Greene. It's not clear that just one statement by a prosecutor that you're going to hear from Sean Williams, especially in light of defense counsel, as Judge Thompson mentioned, suggesting that they may or may not hear from Mr. Greene would have any real weight at all. But then a curative instruction would certainly be sufficient to mitigate, the sort of promise from the government that it was going to hear from Sean Williams.
One of your opponent's arguments about the curative instructions is that in assessing, I think your opponent would agree that there's a relatively strong presumption that curative instructions are effective. So that's helpful to the government for sure. But one of the points your opponent makes is that in cases where this court and other courts have found them inadequate to defeat prejudice, one characteristic that you see emphasized sometimes is that immediate curative instructions are more effective than delayed ones. And your opponent points out that both of the two curative instructions here were delayed by a day. How do you think we should take that into account?
So this court has routinely found that immediate instructions are not necessary to cure the prejudice. In fact, in Williams versus United States, the court found that a curative instruction was sufficient to cure the prejudice, particularly here in light of the fact that with regard to Selenia's testimony, as the direct appeal panel found, her testimony, while potentially prejudicial in some points, was actually sort of diffused by other statements. She testified that Alicia didn't actually seem to be afraid of Mr. Greene. Alicia herself testified that she wasn't afraid of Greene. And given some of the sort of equivocal and counterbalanced nature of her statements, it's not clear that they had much impact at all. But particularly in light of a very strong curative instruction from the court that her statements were without basis, either sort of implying to the jury that they were lies, or at least that they were sort of rumors and there wasn't any factual basis for them, that the jury can be assumed to abide by that instruction. And if I can turn also to the weight of the evidence in this case very briefly, because as this court found on direct appeal previously, the weight of the evidence against Mr. Greene was very strong. You had not only Alicia Whitted.
Actually, was very strong our terminology, or is that your paraphrase of what it was we said in the?
I believe the word that this court used was substantial.
That's the word I was recalling.
And the trial court also called it overwhelming. So in light of either substantial or overwhelming evidence against Mr. Greene.
Well, I know substantial is one of the great ambiguous terms of law, because substantial can mean more than de minimis, or it can mean quite a lot. So anyway, I took from our prior opinion in the direct appeal that we thought the evidence was not overwhelming, or we certainly didn't imply the evidence was overwhelming. We didn't use that term. We used a term that's a fair bit short of it. I think we used it as substantial, and I took it to mean pretty strong, but not overwhelming was sort of the connotation I was giving it. But is that a fair reading, or do you think I'm misreading our actual terminology and what we were trying to communicate?
If this court would allow me to sort of summarize some of the evidence, I believe this court will find that the trial court's conclusion, based on its analysis of the testimony, that it was overwhelming evidence, was actually the appropriate factual finding and not clear error. Specifically, Alicia Whitted testified over the course of 2 days, directly implicating Mr. Greene. She provided sort of step-by-step where the three of them went, the times when Mr. Greene was not with them, the times when Mr. Greene was with them, throughout the course of 2 days. That testimony directly implicating Mr. Greene was corroborated by a number of different factors.
Can I ask you one thing, just to clarify a question that arose during your opponent's argument, which was, I had the recollection that there was testimony both from the complainant of the carjacking and from Ms. Whitted that at some point a male voice from the car was giving directions like check his pockets. Is that accurate or not accurate?
That's correct, Your Honor. So Ms. Whitted testified that Daniel Greene from the back seat of the vehicle said check his pockets as Williams was pointing the gun at the victim. And then the victim himself testified that he heard a male voice from the back of the vehicle say that exact same phrasing, check his pockets. Not only that, but there were a number of other pieces of corroborating evidence that directly implicate Mr. Greene. There was Alicia Whitted's testimony about the drawstring bag that had a gun in it that she stated she'd seen in Mr. Greene's car before. There were exhaustive cell phone and cell site location information that was presented at trial, specifically call detail records that showed that the phone that Mr. Williams had been using was calling the phone that Mr. Greene had been using minutes after the carjacking, and also cell site information that put that down in Southeast in the same vicinity of the carjacking. Particularly that coupled with Alicia's testimony that while she was in the vehicle with Mr. Greene, that she'd seen a call from Mr. Williams come in at least twice and that Mr. Greene did not pick it up. All of that sort of corroborates Ms. Whitted's testimony. And then finally, you have the consciousness of guilt evidence that was presented at trial, specifically that Mr. Greene, months after the actual offense, was approaching Ms. Whitted at her house and telling her to keep his name out of it. which he would have no reason to do if he wasn't actually involved in the carjacking. And then also jail calls where Mr. Greene sort of admitted that he was aware that his friends lied in the grand jury for them. All of this evidence led the trial court to conclude that the evidence was overwhelming in this case. And so for all of those reasons, this court should not find that there is Strickland prejudice because there's no reasonable probability that the outcome of the trial would have been any different. If this court has no further questions, I ask you to affirm.
All right, thank you. Mr. Cohn, you reserved a couple of minutes for rebuttal.
Thank you, Your Honor.
Can I start by just asking you to clarify? You said that the issues, on the issue of whether a hearing should have been granted on the 23-110 motion, you said that the issues were distinct that would have been addressed at the 23-110 hearing, were distinct from the appeal on the merits. But I'm not sure I understand where the distinction comes from.
Yes, Your Honor. The reason a hearing, it was an error of the trial judge not to hold a hearing as to both of the incidents that we've been talking about. With regard to the refusal to testify, the judge in his opinion says the trial counsel stated that she believed that some of the testimony of Mr. Williams would have been beneficial to her client. In a hearing, one would have trial counsel on the stand and say, you didn't know about the Martin case. That's right, I got that wrong. And what benefit did you think you would have by having an announced prosecution witness refuse to testify in front of the jury? And the counsel could testify, okay, here's my thing. It might turn out there was nothing beneficial. It was all detriment. And then turning to the first one, and it gets into what Judge McLeese was discussing, the interrelation between this court's prior decision and the trial court's decision here, which is in the trial court, in finding no prejudice in the trial counsel eliciting testimony that as my worthy opponent here puts it, the rumor that the defendant was a very dangerous person. The trial court relied on this court's statement that it was a brief and isolated comment. And this gets directly, I hope, to your question, Judge, which is that the trial court was looking at that as a isolated comment, but it was not an isolated comment. As one of Judge McLeese's questions earlier of the government said, that the two, in his questions, Judge McLeese said, the two do seem to be pointing in the same direction. This is a very dangerous person. Let's have a hearing and find out what trial counsel was doing. I do want to pick up on a concession that the prosecutor just made, which is that in interpreting the curative instruction, the judge could have said, the jury could have believed maybe the mother was lying on the stand, as Judge Thompson suggested, or maybe it was just rumors. And our system of justice exists so that we don't convict defendants based on rumors, but based on whether, say, the statement, check his pockets, is culpable enough to be able to say, yeah, this guy was aiding and abetting a carjacking. That's what our system of justice relies on. And here, I would just be repeating what I just said, Judge. So thank you for your time.
Ms. Hoover described to us some of the evidence that she suggested caused the trial court to think that the evidence was overwhelming against your client. And one of the things she described, or one of the things were jail calls. I think we do not have the transcripts of those calls in the record. I think the jury got them. My reading of the transcripts is that the jury saw a number of things that are not part of the records that this court has. Do you dispute at all her description of these jail calls?
I haven't listened to them recently, Judge. So At best, they show consciousness of guilt.
Yeah, I looked
As the
at
judge-
some of the testimony. There are a couple of people who were called to testify, Howard with the last name Howard, Daryl Howard, and somebody else Howard, a brother, I think. And it is very difficult in reading the cold transcript to make any sense of what they were talking about. But there are references in the questioning to the transcript of the grand jury testimony or the transcript of a jail call. Only for the reader of the transcript, you don't get the content of it. And I assume the jury got that. And so I guess where I'm going with this is the trial court's assessment that the evidence was overwhelming, was perhaps based on access to those things that I think the panel in the direct appeal never saw. And I just wanted to give you a chance to comment on that if you had any differing assessment of what the jail calls say or what the transcripts show.
I don't have a differing assessment than your honors. I would simply add, basically repeat what I said. I mean, to prove that someone is guilty of aiding and abetting, let's look at what happened that night. Check his pockets. Is that enough to say, oh, he's aiding and abetting a carjacking? That's evidence, but we want the jury to be evaluating that rather thin evidence sitting in the back of the car as whether are we really going to convict this person of, by the way, a very serious crime of aiding and abetting a carjacking? Let's have the jury decide this case based on the facts.
All right, thank you.
Thank you, counsel.
All right, I thank both counsel for your arguments and your briefs today. Our second case this morning is Andre BECTON versus United States. And this is a consolidated appeal.
Good morning, Madam Chief Judge, and may it please the court. My name is Greg Lipper. I represent the appellant Andre BECTON. I would like to reserve 4 minutes for rebuttal. The trial court, after the 23-110 hearing, correctly concluded that had a suppression motion been filed by trial counsel, the fruits of the search of Mr. BECTON's iPhone almost certainly would have been suppressed because the affidavit in support of the warrant was manifestly lacking in any indicia of probable cause to believe that incriminating evidence would be found on that phone.
How do you respond to the fact that trial counsel in this case, in testifying at the 23-110, indicated that part of the reason that they didn't file the motion to suppress was concern about whether it would have withstood the rule allowing them to proceed based on the fact that the warrant had been signed, the good faith exception?
So I'd say 2 things. First of all, I think trial counsel's subjective belief that might apply ultimately would not salvage a decision with an omission that was objectively deficient. And the trial court, although the trial court didn't say explicitly the good faith exception does not apply, the trial court's conclusion that the affidavit was completely devoid of anything resembling probable cause is in essence a conclusion that the good faith exception would not have applied. The other point I want to make simply is that trial counsel said explicitly that his decision not to file a suppression motion was not a strategic decision. Suppression motions, they often, a suppression motion in a trial court, I mean, it's 4 or 5 pages, but it's not usually a comprehensive appellate brief, in part because there's going to be an evidentiary hearing where the facts are going to be fleshed out. And so trial counsel's mistaken belief that the good faith exception might apply would not affect the conclusion that performance was deficient when in fact it did not, when in fact the exception did not apply. So I think that the trial court was correct about the deficient performance conclusion, but where the trial court was incorrect was in concluding that Mr. Becton was not prejudiced by this omission. And I think there were two sort of categorical errors that the trial court made in its analysis of prejudice. The first was the prosecutor concluded that the evidence against Mr. Becton was overwhelming, but virtually every example of evidence that the trial court cited in the oral decision went to the identity of the shooter, which was not in dispute at trial, and didn't really address the disputed issue, which was self-defense. And so overwhelming evidence that Mr. Becton was present and the shooter.
Well, but the trial court does in large part rest her rationale for finding no prejudice on the fact that this self-defense claim was not in tension or conflict with what the cell phone evidence was likely to show.
And so that's what I think was the second categorical error, and for a couple of reasons, and I'll.
In other words, she said it was consistent.
That is what
And therefore, how could it be prejudicial?
That is what the trial court said, but I think the fact that it was theoretically consistent with the defense doesn't mean that it nonetheless didn't harm the defense. And notwithstanding the theoretical consistency, it harmed the defense in two specific ways. And I think the first and most important of those is that because the search of Becton's iPhone revealed that there had been either records of phone calls or text messages that had been deleted within 2 days after the shooting, it allowed the government to emphasize those deletions and argue explicitly that the deletions reflected consciousness of guilt. I cite in my opening brief the old adage that it's often the cover-up is worse than the crime, and that deletion of material, deletion of communications within 2 days of the shooting was, I think, much harder to address and recover from than Mr. Becton's,
I'm sorry to interrupt, but am I correct in understanding that some of those deletions related to searches about whether a pending bench warrant was out for him?
No, so there were
two separate.
There were two separate things. There was evidence that Mr. Becton had searched for to see whether there was an outstanding warrant, so that we knew what the content of the search was. There were also, though, and the way this was determined was the government separately got the cell phone records from Mr. Becton's cellular provider. And so the government showed the jury was, look at these 4 calls or messages that I think it was T-Mobile, but just that were in the T-Mobile records. They're not on Becton's phone. And so the government said, and there was this refrain in the closing, quote, those searches, comma, those deletions. And the deletions, the government even highlighted the deletions in red. It encouraged the jury to look at those things during deliberations.
And you were going to say, because your opponent argues, and I think the trial court was persuaded to a degree by this argument, that that all may be true. The government was trying to rely on it for consciousness of guilt, but the government had a bigger exhibit in the consciousness of guilt parade, which was that your client, although asserting self-defense and acknowledging through counsel that he had been the shooter, when interviewed by the police online for the shooting, said it wasn't me. So that's definitely seems like, at first blush, it seems like a bigger, that's kind of the conscious of guilt elephant in the room, to pick a different metaphor. And so you were going to, I think, try to explain why you think the trial court and your opponent are incorrect to think that the marginal significance of this conscious of guilt angle was not that great in light of the conceitedly false denial of involvement to the police.
Yes. So, and I agree with you at first blush, but I think at second blush and during deliberations, the deletions were actually more significant for a couple of reasons. The first is that there was a lot of evidence, not only from what Mr. Becton said during the interview, but also from a third-party civilian witness and from the interviewing detective, that there is this widespread misconception amongst people in DC that there isn't a self-defense defense under DC law, I think because it's not explicitly codified. And so for whatever reason, there is this widespread, seemingly undisputed at trial, widespread misconception. And so the argument.
And just, I mean, I
Yeah.
get that, but that seems also to be equally explanatory of the deletions. If I think, I wrongly think I shot somebody in a way where I have no defense, so I deleted some stuff and then I lied to the police about it. All that seems consistent with that line of thinking. So far I haven't quite
Okay.
seen how they diverge.
Right. So here's why I think the deletions are worse, because with the statements that Mr. Becton made to the detectives, we know exactly what he said and what he said that wasn't true, and that could be addressed with specific evidence. Okay, he said this, but this is why he feared. The problem with the deletions is it's precisely because we don't know what they said, and so the jury is left to wonder what was in there. Did he, text someone and said, "Oh, I just, I had it with him and I took, matters into my own hands," or whatever. It's precisely because we don't know precisely what was in them that there is less ability to address them as trial counsel did the statements in the interview. It allows the jury to wonder, and it has that sort of deleted evidence that, the modern day equivalent of shredding evidence that that I think is just, it was impossible to explain because we didn't know exactly what was in them.
Can I interject again? Because I know that there was opposition to allowing this evidence to come in, or there would have been if the suppression motion had been filed. You mentioned that during closing argument, there are some statements of the government's counsel about these deletions and highlighting them. Was there a objection, and then was there rebuttal argument about them at trial?
There was not an objection, and did not find that surprising, just because there, in any case, there's a pretrial schedule set, and once the motions deadline has passed, so if the motions deadline has passed and trial counsel is not moved to suppress the evidence, then that that motion can't be resurrected later. It can't be a Fourth Amendment argument can't be resurrected at trial.
Not the motion, but the contemporaneous objection to the argument at closing.
But I think by that point there wasn't a basis to object, because there had been other cell phone evidence that later on, the trial counsel had specific subsets the trial counsel had managed to exclude on non-constitutional grounds, but without any suppression motion filed, and thus with the Fourth Amendment argument never raised, procedurally, there was no way to contemporaneously object orally to evidence coming in the absence of a written suppression motion.
And anything in rebuttal by defense counsel that might have tempered or lessened what you say the impact may have been of those statements?
Not really. There was on the self-defense, on the statements to the detectives in the interview, but not really on the deletions, again, because we don't know what was in them, and that's ultimately the problem. The jury is left to imagine what is in these deleted, calls and or texts that was deleted within 48 hours of the shooting. And I do think that is, more materially, in addition to being an additional thing that the jury is thinking about, it is materially different in the impact and the inability to really rebut or address it well.
Can I ask you about so you've focused so far on the deletions, but there also was the search history and the warrants. And again, at first blush, one could think, I think that those searches, if I have my chronology right, so please feel free to correct me, those happen after a time when he might have had reason to believe the police were investigating and they found a gun at a friend's and all that. So, it's kind of, he would be thinking the police seemed like they're after me. They're on the path to me. And he's looking to see I wonder if there's a warrant out for my arrest. If his theory is I was involved as a shooter, but in lawful self-defense, which I now know is lawful, but I didn't. And if that's how he's explaining his denial to the police, again, at first blush, it's not entirely clear how marginally prejudicial the search warrant, the search history is. So
So I will say, I think the deletions were more prejudicial than the searches. The reason why I think the searches still added to the prejudice was that it does, once you have the defendant kind of doing internet research about the law, it would enable the jury to infer, because again, the jury didn't have to believe that Mr. Becton didn't think there was a self-defense defense. And if the jury knows, oh, this is a guy that knows his way around, internet research about legal issues, then I think the jury also could have concluded, well, he might have also, perhaps he also researched self-defense or was savvier than he had let on in the interviews.
Although, is it accurate that that's not a use of the evidence that the prosecutor expressly made to the jury in closing? They didn't say, like, by the way, these search history is pretty revealing, because he's claiming he doesn't even know self-defense, and then he is out, doing technical research about warrants and the like. That's not an express argument that was made.
It was not an express argument, but both.
Fair enough, but
Yeah.
I just have one question about the express argument that was made, because the United States, in closing, if I'm recalling correctly, does make the conscious of guilt set of points about the cell phone material.
Yes.
But it also, I think, said at one point that the cell phone information, the extraction, I think they were calling it, corroborated some testimony, corroborated the testimony of Ms. Moore.
Yes.
Maybe. Do you know what they meant by that, or do you view that comment as tying into a kind of prejudice that's different from a conscious of guilt line of thinking?
We looked at that, and there was actually some discussion of that at the hearing. I did not read that as to be making a specific point tied to say the eyewitness testimony or whatnot. I would say though that I think the prejudice there is that the prosecutor said objective evidence, which included in the trial, the prosecutor enumerated the various pieces of objective evidence, which included those cell phone records, corroborated Ms. Moore, and did the refrain about objective evidence doesn't get drunk, doesn't forget, doesn't have bias. So I would say that the cell phone extractions were a prominent piece of the quote objective evidence that the prosecutor was explicitly using as a way to reinforce the testimony of Ms. Moore. And the testimony of Ms. Moore, I think, really did make the government's case quite weak, both because not only did Ms. Moore have many credibility problems, but a lot of what Ms. Moore said actually supported self-defense, including testimony or a prior statement that Mr. Peoples had actually been reaching for Mr. Beckman's waistband area before the gun came out.
No,
Are you?
I'm sorry.
No, go ahead.
Earlier, I know you draw a bit of a dichotomy and distinction against the identity evidence and then the evidence related to this materials extracted from the cell phone. But the identity evidence is pretty strong here with the dying declaration and with much of Ms. Moore's testimony, assuming that the jury credited it. And I think here where the jury declined to convict on the first-degree murder, but convicted on second-degree murder, we can assume that the jury is discerning about some of this testimony. And so why shouldn't we discern or presume that they credited perhaps some parts of Ms. Moore's testimony and maybe not as strongly other parts of her testimony, as opposed to the fact that she was completely discredited?
Well, I think obviously we don't know for certain, but I think the difference between the first and the second degree verdicts actually reinforces the prejudice, because for first degree murder, and the prosecutor highlighted this, the sole piece of specific evidence cited as evidence of premeditation was Ms. Moore's testimony that she heard Mr. Becton count down or count to 5 before shooting. And had that testimony been credited, Mr. Becton would have been convicted of first-degree murder. Second-degree murder, however, did not rely only on Ms. Moore's testimony, because the government had all of this, quote, objective evidence that doesn't have memory issues, doesn't get drunk. And so we actually have a bit of a natural experiment. When the evidence is Ms. Moore only on first-degree murder, we got an acquittal. And when evidence was Ms. Moore plus objective evidence, including the cell phone extractions, we got a conviction. Obviously, in the absence of—
And the dying declaration.
Well, but the dying declaration, again, identity was not disputed. In the opening statement, the defense conceded that Mr. Becton was there and that he shot Mr. Peoples in self-defense. I mean, even the dying declaration I would say Mr. Peoples, during his dying declaration, the substance of what he said about the circumstances was that Mr. Becton shot him because he was old and that he was going around shooting a bunch of other people. And that, understandably, that was not accurate. So even the dying declaration, it's perhaps good evidence that Mr. Becton was the shooter, which wasn't disputed, but it is most definitely not probative of the circumstances of the shooting.
Are you going to talk about the exclusion of the evidence about the domestic incidents?
I am, yes. Before I continue, I see my time has expired. Should I
Well,
proceed?
you can continue with where you were going. And
Okay.
I'm sure the chief will give you a.
Or you could answer Judge Thompson's question.
Fair enough. I will. So yes, I mean, briefly, the testimony from Mr. Peoples's widow was that not just that he was a jokester and being jovial when she talked to him on the day of the shooting, but more generally, he was a jokester, jovial, liked to make people laugh, always trying to, smiling, et cetera, et cetera. She was talking more generally about his personality. And the prosecutor, relied on that in closing. And secondly, when the defense drug expert testified about Dr. Blair testified about how PCP can cause, people to become violent, the government cross-examined him and then argued later on that that was merely stereotypical. He was resorting to stereotypes and, because he didn't have information about the individual's characteristics or personality. And both of those arguments, which, in piece of evidence, which the government opened the door to, would have been directly refuted by 3 instances, one of which was, had been within the past year, in which Mr. Peoples had been violent and aggressive, to the point of leaving multiple bruises and marks and whatnot. And because that wasn't allowed in, even after the government opened the door, the government was able to argue, Mr. Peoples was jovial, was a jokester. Mr. Becton is the kind of person that overreacts and takes things too seriously that he shouldn't have. And the defense was not able to rebut that picture of Mr. Peoples that the government's, witnesses and argument created. So that.
In fact, I mean, I was struck by the closing argument by the prosecutor because not only did the prosecutor say that Mr. Peoples was a jokester, but a couple of times he said things, or she, I forget which, said things like, at no point did Mrs. Peoples say that Mr. Peoples was violent or aggressive.
Yes.
He was not violent or aggressive. So it seems that might have had some effect.
Exactly. And I think, I don't think the government doesn't really dispute that Ms. Peoples was talking about his broader personality. The government makes the argument that calling someone a jokester isn't inherently positive because of, the famous cartoon villain, the Joker. But I think any jury would have been able to distinguish those things. And had trial counsel gone up in closing and said, well, he's a jokester, but look at the Joker in Gotham City, I think that would have backfired spectacularly on the defense and probably would have earned a reprimand from the judge as well. So I think there was this picture painted, and especially when the door was opened by the government and there was both contemporaneous accusations, corroborated by physical evidence of bruising. The final point I want to make there, which is something that both the trial court had pointed out, that there was no evidence that Mr. Peoples was high on PCP during those prior violent incidents. But I think nobody is suggesting that PCP makes people more peaceful. So at best, the government was arguing that the PCP didn't make Mr. Peoples more violent or more aggressive, but he was already prone to violence when sober. At a bare minimum, the PCP that he was high on that night would not have made him, any less violent or aggressive than he normally was capable
Well,
of
what do
being.
you make of the trial judge's finding with respect to, and when one of the reasons she gives for denying the admission of this evidence is that the alleged domestic offenses for which he was not convicted of, he was also not under the influence of any drugs. And in this instance, he was. It seems to me that finding could cut both ways, but how do you assess it?
I agree, and I think, you know, had his drug of choice been, and I'm not a pharmacologist, but had the drug of choice been something like Xanax or like a tranquilizer, something that calms people down, I think that might have been relevant. In other words, he was aggressive when he was unmedicated, but he was, you know, much calmer and more peaceful when he was, you know, taking Xanax or abusing Xanax or whatever he was doing. But here with PCP, there's no suggestion or evidence that PCP ever reduces people's violent urges. So
There was no suggestion, or at least there was contrary suggestions in the testimony about Mr. Peoples. When he approaches the appellant, he says, "I love you, man." And some people describe that approach as an attempt to hug him. Hug Mr. Bent.
Well, and just to be clear, the only witness, there was just one person, it was just Ms. Moore, that was the only eyewitness that testified. At various points, she has described what he did as tried to hug him, tried to grab him, some combination of those things. But ultimately, it was undisputed, even by Ms. Moore, that when Mr. Peoples put his hands on BECTON, whether it was initially a hug or a grab, Mr. BECTON gestured to try to get Mr. Peoples' hands off of him, and Mr. Peoples continued to accost and reaccost him. And then you have, and
I don't know if anybody used the word accost.
I don't know that the word accost was used, but what Ms. Moore was describing to some extent in her testimony at trial and with prior statements that she was impeached with was that whether or not the initial approach was a hug or a grab, that it proceeded into, you know, tussling and Mr. BECTON not being able to free himself.
Was there any testimony that refuted the statements that Mr. Peoples actually allegedly said, "I love you, man," as he approached Mr. BECTON?
Well, there was, because Ms. Moore was the only witness, I mean, Ms. Moore was impeached fairly comprehensively, so the jury could very well have decided not to credit that particular statement. But I mean, the thing that was undisputed was that, you know, whether you call it a quote joke or not, I think the connotations are quite serious, which is that the encounter started by Mr. Peoples, you know, shouting anti-gay epithets at Mr. BECTON and the other people. So whether or not he then said, "Oh, I love you, I'm just joking," I mean, it started off in I would say a non-friendly posture. And it was also, and again, Ms. Moore has had a number of different statements, but you know, for instance, she was impeached with the written statement she had given to the investigator earlier in the year of the trial, in which she had, you know, talked about that it was much more of Mr. Peoples sort of grabbing at him. The government even actually tried to rehabilitate that testimony because Ms. Moore's testimony had been slightly more favorable to the government immediately afterwards, and then unfavorable to the government in the written statement earlier in 2019, and then more favorable to the government at trial. The government at one point tried to, I would say, semi-leadingly rehabilitate Ms. Moore. It was like, "Ms. Moore, was your memory better earlier this year, you know, when she gave the statement, or at the time of the shooting when she gave the statement to the detective?" And Ms. Moore said, "Oh, this year." So even when the government tried to rehabilitate it, Ms. Moore kind of reinforced that her memory was actually better when she gave the statement, the written statement. And that written statement was far more along the lines of, you know, Mr. Peoples accosting. But
Right, Mr. Hufford. I know we've been very generous with our time here, but
The way you've structured your argument, it sounds like you think that the deletion of the material from the cell phone, the extractions, was more prejudicial than the exclusion of this testimony about the domestic incidents. That was part of the reason for my question, because my own initial take was the opposite, that given the statements the prosecutor made in closing about the absence of any evidence that Mr. Peoples was aggressive or violent, it really went to the self-defense defense, and perhaps was more persuasive or would have been more persuasive if admitted than the other. What's your response to that?
I don't know that I think one is more or less prejudicial than the other. I would say the order of operations, for lack of a better word, is just more to the fact that the Fourth Amendment ineffective assistance argument was sort of had more pieces to it, so it just seemed like the sort of thing that should go first. But no, I agree. I think it was a significant factor, especially because there's actually, I think, quite plausible that if Mr. Peoples was hostile to BECTON, coming up to him, putting his hands on him, not taking his hands off, and then, as Ms. Moore said in her previous statement that she was impeached of, reaching for in the area of Mr. BECTON's waistband where his gun was before the gun came out, that would have, made Mr. BECTON quite reasonably afraid for his safety and life that Mr. Peoples is going after the gun. I would also note that in the Burns case,
Mr. Lipper.
all right, I will.
Thank you. You reserved a few minutes for rebuttal, but we've taken you well over your time.
Thank you.
Good morning. May it please the court. Mark Hobel for the United States.
Good morning.
And I'd like to begin with the ineffective assistance claim and focus on prejudice, as most of the court's questions to Mr. Limper went to prejudice. And then I'd move to address the first aggressor propensity evidence and the trial court's decision to keep that out. Of course, under Strickland, this court can affirm the trial court based solely on prejudice. Strickland is clear that's typically the case, doesn't need to reach deficiency. And while I usually don't like to quote just directly from a case, I think an overarching point from Strickland would be helpful here in assessing the prejudicial or lack of a prejudicial impact of the phone evidence. And that is that, as quoted in our brief on page 35, potential prejudice must be assessed against the totality of the evidence. While some errors will have had a pervasive effect on the inferences to be drawn from the evidence, altering the entire evidentiary picture, others will have had only an isolated, trivial effect. And the phone evidence here certainly was the latter category, an isolated, trivial effect. The trial court, which had an expert vantage point, sat through the whole trial, saw all the evidence come in, heard the arguments. Trial court found that it had marginal, limited, and insignificant impact on the case as a whole. This was evidence that the government mentioned in his closing argument, really only because the government didn't take any time during the presentation of its evidence to discuss this. It just moved kind of the documents in en masse. The government did not address this at all in its rebuttal, didn't mention it all in its rebuttal. And I think perhaps most tellingly, the defense in its closing argument just owned the phone evidence, said this is totally consistent with our theory of the case, which is that BECTON was afraid and worried because he thought he'd done something bad because he doesn't understand that there is self-defense law in the District of Columbia. That explains his lies to the detectives, and that also explains the fact that he may be getting rid of stuff on his phone and that he's looking for whether there are warrants out for him. So from that perspective, again, this is
Counsel, can I ask you, on the one hand, I think, could we view it two different ways? The fact that the government didn't really touch much on this cell phone evidence during trial, but then does raise it in closing argument at a couple different points. And we've said at times that arguments made during closing argument could have a greater prejudicial weight, perhaps, because they're the last thing or close to the last thing that the jury hears. And the fact that the government does talk about these deleted messages more than once in closing argument, how do you respond to that?
Well, the last thing that the jury hears is the government's rebuttal, and we did not mention it at all in our rebuttal. So I think that's That's the counterpoint to the proposition Your Honor has put forward. The other, in assessing evidence, I think the court has said, look at how much the government brought this, emphasized the evidence in toto. That's a factor that the court can consider in assessing whether the government thought this was strong evidence. But the cases where this court has found that the government, emphasize the evidence is because they emphasize it in opening. They emphasize it through the questioning of witnesses. They emphasize it in closing. They emphasize it in rebuttal. Here, the reason that the government, had to bring this up in closing, had to put red, boxes around parts of the evidence in its PowerPoint is because it hadn't brought this to the jury's attention at all through the entirety of the case. And at the very last moment said, oh, by the way, here's another point that's consistent with our theory of the case, which is that he didn't act in self-defense. And you know that because he lied to these detectives about
Can I
self-defense.
ask you,
Yes.
in addition to teeing that up in closing as conscious of guilt, as I mentioned to your opponent, there's also a reference by the prosecutor saying that the cell phone extraction corroborated Ms. Peoples' testimony. Do you understand what that means or how that corroboration operated? Because it was a little opaque to me.
When I heard you ask Mr. Lev, I confess that I didn't recall the exact point from the closing. My recollection is that the government did say that the objective evidence corroborated Miss Moore, who was the eyewitness, and that the objective evidence included surveillance video, ballistics evidence, the car, and there were various categories of objective evidence. And then it said, oh, by the way, there's also objective evidence from the phone. But again, the phone evidence ultimately was treated as an afterthought.
Here's, this page 91 of the transcript of the closing, and it says, now, the phone extractions, they corroborate with what Ms. Peoples said, but they also go to the defendant's state of mind as conscious of guilt.
Right.
That's what I'm
And
referring to.
I'm not, they corroborate her in the sense that she indirectly identifies BECTON as the shooter, but there was no dispute. I guess I'm just not sure how I'm not sure what they meant by that. They do then go to the consciousness of guilt, but as Your Honor pointed out in discussing with Mr. Lepper, there was already profoundly strong evidence of consciousness of guilt. That is that BECTON went in before he was arrested, met with detectives, and denied up and down that he shot the victim, that he acted in self-defense, that he was afraid, even when the detectives told him, look, there is self-defense law, it could exonerate you. And BECTON continued to lie to him. So if the jury was going to put a lot of emphasis on consciousness of guilt evidence, they were going to focus on the big consciousness of guilt evidence. And at best, the phone, the deletions, and the internet searches were going to be a marginal kind of cumulative addition to the already profoundly strong evidence of consciousness of guilt. On the other hand, if the jury was prepared to accept the defense's explanation for why BECTON had told the detectives that he didn't act in self-defense, that is, that he didn't understand that there was self-defense law in the District of Columbia. If the jury was prepared to accept that explanation, a reasonable jury wouldn't change its mind based on just some marginal additional evidence, the marginal additional evidence coming from the phone. And the standard under Strickland is, what would a reasonable jury do? And it doesn't wash to say a jury that is prepared to believe the defense's explanation for what BECTON said to the detectives, why he lied to the detectives, is not really buying the government's consciousness of guilt theory. All of a sudden is going to flip on a dime because of this extra, this kind of afterthought phone evidence.
Well, but I think you could draw some distinction between the phone evidence. On the one hand, the search for, is there a warrant out for me? That might fall into the category of he's just worried about the self-defense claim. But if you look at the deletions of some mysterious texts that were deleted, couldn't that conceivably lead the jury to begin thinking, well, what was he trying to hide? If this was self-defense, well, why is he worried about deleting text messages so close in time to the event?
I just don't think there was enough there for the jury to, but I also don't know that we could have argued you should speculate about what those communications were. But I guess maybe an overarching point about the ambiguity of this evidence is if this had been really damaging to the defense and the defense theory of the case, the defense would not be owning it like it did. The defense would not be saying, oh yeah, he deleted messages, he searched for a warrant, that shows he's afraid. The defense would be pointing out, look, the limits of the government's evidence here is they can show you his call detail records and they can show you the records from his phone and they can compare them and point out what's missing from that. There are some in the call detail records that are missing from the phone, but that doesn't necessarily that doesn't necessarily mean that BECTON deleted them. We don't know when he did. We don't know anything about who this number was that he was communicating with or what this had to do with. There are profound limits to this evidence. And the fact that if this evidence was really bad for the defense would have brought out the weaknesses in it. But it wasn't. It was consistent with the defense theory, which is that this is a guy who is scared, who is on the run because he believes that what he did is wrong. He has a false consciousness of guilt. And ultimately, it was the
So I was never a defense attorney, but it just seems to me if I had been one, I would have been pretty leery of trying to respond to this evidence by getting the jury to speculate about what was in the missing texts. I would have thought that could backfire rather than be a way of trying to deal with that evidence.
right. And that's a fair point. I've never been a defense attorney either, but my experience is that when you have damaging evidence that when as a government we bring out damaging evidence that is truly damaging to the defense case, the defense does try to explain away and does try to defeat it and does try to downplay the inferences that the government suggests you try to draw from it. Here, the defense said, no, we agree. This shows that, he was worried. This shows that he was afraid of what was going to happen. And that plays into our theory that he had this false consciousness of guilt. And so at the end of the day, the judge, I think the trial judge, who again had the expert vantage point of being able to sit there, review the entire evidence, see all the arguments, see the jury's reaction, how this whole case came out, was I think Judge McKenna was very confident to say the evidence again, the other evidence was simply overwhelming, and the phone evidence was marginal and insignificant. And
Can I see the way you were just formulating that got me to wondering, you're emphasizing the trial court's superior position in assessing this, but you will agree, I think, that whatever one might think of that as an original matter, our review of this is de novo. So we're not to defer to the trial court. The system may be that the trial court would have been better at making that judgment than we will be, but we're required to review it de novo. Is that correct?
I do agree that the standard review is de novo. I would suggest that I would refer the court to a recent circuit opinion by Judge Millett, United States v. Adams. And I'm happy to submit a 28K letter because I realize this was not in our brief that discusses the trial courts. While the review is de novo, the trial court does, in assessing prejudice, the trial court does have an expert vantage point. I believe those were the words she used, but I'm happy to submit a 28K letter. But despite there being de novo review, that doesn't mean that the trial court's weighing of this evidence is not entitled to persuasive weight. And here it is, because it makes sense. One quick point I just want to add is that Deborah Moore, the eyewitness, was really the sole basis from which the defense could even argue self-defense. I mean, there's no other self-defense evidence in this case. So suggesting that Deborah Moore was heavily impeached, and she was impeached on certain points, suggesting she was is a double-edged sword for the defense, because without her testimony, there is no self-defense case at all. All this,
I'm not sure that's right. I mean, again, if I were a defense attorney and I'm able to say in closing, the government's own witness supports my self-defense claim, but is terrible in every possible respect, that seems like a pretty good synergistic, reasonable doubt kind of argument. I don't think the in order to raise reasonable doubt about self-defense, the defense would have any need to vouch for the witness as opposed to hacking away at the witness, but also saying, look, even, you know, even at her best, she helps self-defense, and she is you really shouldn't believe her for anything. If you believe her for anything, then it's just self-defense. So I'm not quite sure it's a double-edged sword in the way that you're suggesting.
Right. I think that's another way to look. I'm not going to disagree with you on that's fair. But on the other hand, if you take Deborah Moore's testimony out of the equation, you know, you have the defendant undisputedly shooting an unarmed man twice on a public street where the defendant was with his friends. And, you know, at best you could say that there was some PCP in people's system. But you know, it's Deborah Moore really is, I mean, she's obviously an important government witness, we're going to call her. She's also the linchpin of the self-defense case here. But again, I think this frankly goes to, notwithstanding that isolated comment in the closing from the prosecutor that I didn't recall, and I'm not sure I fully understand how it corroborated her testimony. The phone evidence ends up being pretty separate and distinct from Deborah Moore's testimony. The phone evidence is just, it's kind of a sideshow. And then I think in the aftermath of Burns, Burns obviously spawned sort of some new claims about cell phones that.
Before you run out of time, are you
yeah.
going to say something about the ruling on the domestic incidents? Because it seems to me that evidence or what the prosecutor did with that evidence in closing arguments really potentially had more impact. I mean, again, the prosecutor said, Mrs. Peoples never said Mr. Peoples was violent or aggressive. You know, 2 pages later, there's no evidence that he was ever violent or aggressive. And yet that went to the self-defense claim. So what do you make of that?
Yeah, I think there was some testimony and, you know, I confessed, Your Honor, too, that I don't have the specific wording at the top of my, but there was discussion. There was testimony from Sherry Peoples that on the night of the incident, she spoke with her husband and he was in a good mood. He was jovial. And that does actually corroborate what Deborah Moore said about how he was acting. He was in a joking mood. That doesn't open the door to sort of first aggressor propensity evidence well, let me take a step back, actually, because in order to get first offender propensity evidence in, the defense would have had to satisfy the Shepard test.
Can I slow you down for a second? Because it seems to me there are 2 distinct arguments.
Yeah.
They're related, but they seem potentially distinct. One of them is the sort of Shepard first aggressor line of thinking. But even you could think of as not really supportive of that, but a distinct argument, sort of an opening the door argument, even if Shepard isn't itself, its requirements aren't, the doctrine that was at issue in Shepard wasn't met, that it's just in fairness, if the government decides that it wants to paint a picture to the jury of the decedent here as not just in a good mood on the day of, which the government certainly was doing, but also to say more generally, he's a fun-loving guy and the like. So they're painting a general picture of his character on an issue. Leaving aside, you know, first aggressor and special doctrines and homicide cases and the like, there's just an opening the door doctrine of if the government's going to try to do that, then the defense ought to be permitted to respond. And I think those are 2 distinct questions, both in conceptually, they're related, but they're distinct conceptually and as they were briefed. So I just want to make.
I understand the distinction. As I understand the defense's argument, they're not directly claiming the trial court abused its discretion in admitting the first offender. I'm sorry, the first aggressor propensity evidence under Shepard prior to trial. What they're saying is that Sherry Peoples' testimony about her husband opened the door to first aggressor evidence. Her testimony, Sherry's testimony, was that he liked to joke around. He liked to have fun. And this is why Mr. Lipper and I have been debating The Dark Knight and the Joker, because from our perspective, testifying that somebody likes to joke around and have a good time doesn't lead to the inference that they are a peaceful person and open the door to propensity evidence to direct that. Sherry never testified that he was a peaceful person. She testified that he liked to joke around. Second, I think even if, second is that when the defense sought to introduce the propensity evidence during Sherry's testimony, the defense's specific argument was she is painting a false picture of their relationship. She is saying that everything was good, and so we want to bring in a domestic violence incident from like 3 years ago. And the trial court, exercising reasonable discretion under Rule 403, and balancing the probative value against the danger of unfair prejudice, said you can cross-examine about the fact that the decedent was having an affair with another woman at the time he was killed, to cross-examine her about this picture she's painting about the relationship. But a domestic violence incident that just resulted in an arrest, no conviction from 3 years ago, that's just going to lead us down this road of many trials and is going to consume time and is going to mislead the jury. So, ultimately, it wasn't like the specific testimony that the defense in the moment found problematic. They were permitted to cross-examine and bring in this extramarital relationship.
And what about the objection in closing, which you said you may not have the exact wording in mind, but the language that Judge Thompson was referring to is the prosecutor in closing talking about the sort of effort to impeach Ms. Peoples a little bit about their relationship, and they had an argument and all that, and then she talks about they talked about what they were arguing about, and then this is the sentence. But at no point, even in drudging up that painful memory of her husband, did she say that Kirk, even in arguing with Kirk, was violent, aggressive, incoherent. She never said that he was intoxicated. I never said that. So again, I guess read one way, it could be on the date of the incident he wasn't violent, but at no point language has us. And he was jovial. He was a jokester. Again, being a jokester, not a day of condition, but a general persistent apparent trait of character. It seems like that was at least arguably could be read as some of the other testimony was as not day of evidence, but also generally what he's like. He's a jovial, fun guy. He likes to likes to make people laugh, not just that day, but generally he likes to make people giggle. And so it seems like it is not an unfair concern that the defense is raising about the testimony and the argument in closing, that there is an effort to run beyond day of and instead to try to paint a friendly, happy, nonviolent picture about the decedent.
Well, I know I'm not the one that's supposed to be asking questions here, but was there I don't know whether there was an
objection overruled.
Objection overruled. Okay, so there's been no claim about that argument that's presented here. I don't recall it coming up in the briefs. Mr. Lipper can correct me if I'm wrong. I mean, at the end of the day, it's still the case that, even if that objection, which again is not, that objection should not have been overruled, it should have been sustained and stricken. That's not particularly prejudicial here in the context of this trial. Cherie is
I understand what you just said, because I wasn't quite sure how to punctuate what you said.
I'm sorry.
Just the ambiguity of spoken language. But were you saying even if it should have been excluded, it wasn't prejudicial, or were you saying you actually think it should have been? The should have been sustained.
Just because I'm right. I mean, I'm not sure about the because they haven't made a claim about that comment in the argument. I can't take a position. I'm not really prepared to take a position for the first time here with respect to I don't think that comment undermines the correct at the time evidentiary ruling of Judge McKenna, because these the admission evidence has to be assessed at the time it's actually admitted. And to the extent that there was a prejudicial comment in argument, again, that's not a claim that the defense has raised. We've also addressed harmlessness in the context of this argument that, had Cherie been asked about that prior incident, she may well have testified that, and the trial court recognized this at the time, that Peoples had basically tried to stop a fight between Cherie and a woman named Miss Gaskins. And then in doing so, he had ended up pushing Cherie, but that he was trying to play the peacemaker there, which would have played into the government's argument. And then finally, I do just want to address one final thing. Unfortunately, I realized in preparing for argument, we had made page 47 of our brief. This is the very last page in addressing harmlessness, making a harmless error argument about the first aggressor propensity evidence. We had pointed out that it might have opened the door to violent propensity evidence for BECTON. And I had cited to Federal Rule of Evidence 404A2B2. It turns out in preparing for argument that this court I'll cite the case Carter v. United States 475A2D 1118 from 1984 has indicated that first aggressor propensity evidence about a victim doesn't open the door to similar evidence of a defendant, although it would open the door to the decedent's character for peacefulness. So I guess I would just ask if the court can just disregard everything on the last page of our brief from our citation to Brooks v. United States after that to the end, but the footnote 10, which doesn't have to do with that error, and obviously I apologize for that, footnote 10 should remain in there, but just want to make sure we're not putting any bad law in front of the court. I see there being no further questions, and obviously on the cell phone, we've substantially briefed the cell phone issue. We're happy to just submit on that.
All right, thank you. Mr. Lippert, you have a couple of minutes for rebuttal.
Thank you. I want to start with the evidence about Mr. Peoples' violent acts. The first thing is I think Judge McLeese is exactly right that the center of our argument on appeal is that whether or not it was admissible in the abstract, that the government opened the door with Ms. Peoples' testimony and then reinforcing that in its closing. And we quote not only Ms. Peoples' testimony, but we quote the closing extensively, both in the statement of facts and in the argument itself. And I just want to, there's kind of a lot of paraphrasing going on. I want to quote Ms. Peoples' testimony, which was clearly about his general characteristics. Quote, "He was silly, he was funny, he liked to make people laugh, he liked to make people smile." That is not only talking about general characteristics, that is completely inconsistent with him being a menacing cartoon villain, because the Joker in Batman didn't like to make people smile. He had a persona, but he liked to harm people. And then just to reinforce that Ms. Peoples is talking about general characteristics. So what I just quoted from was on page 51 of the, page 59 of, I believe it's March 26th, her testimony on March 26th. And then on page 61, she goes on to say that that day, Mr. Peoples was smiling, in a good mood. And then she adds, quote, "like he normally do." So even when asked about his personality that day, she linked it to his broader omnibus personality. And then one other point, just in terms of the closing, that the prosecutor did two things that I think amplified the prejudice even more. Number one, the prosecutor said, quote, "in addition to the eyewitness testimony, the quote, people who knew Peoples and how he behaved is the foundation of the heart of the case." And so the government was treating knowledge of Peoples writ large as sort of co-equal with the eyewitness testimony about the shooting. And then in rebutting the defense expert who testified that PCP can make people aggressive, the government argued that the defense was relying on stereotypes because there wasn't any information about linking that to Mr. Peoples' personality. Obviously, that would have been a very different inquiry if the defense could have asked their expert, Dr. Blair, given someone who already has a history of violence, what effect would PCP likely or might likely have on that person? That would have been a very different scenario.
Can I ask you about that? Because
Yeah.
I mean, I think that's an interesting line of thought. I was uncertain that it was raised to the trial court in that form to say, leaving aside the opening the door concern that I have, they're offering an expert and we have information that we want the expert to be able to, have the expert consider, when we're asking questions on cross about, well, what would this affect your opinion or wouldn't it? I just wasn't aware that the kind of connection of this line of thought to the expert's testimony was framed for the trial court.
I think that is correct. I do think, though, that if you find that it was error to exclude the evidence, that is a fair game to consider in the harmless error argument, which is by definition sort of raised for the first time on appeal. I see my time has expired. I have a sentence or two if the court will permit me, but otherwise I will happy to submit.
Is this a Mr. Lipper sentence or a sentence sentence?
That's a somewhere in between. Touche, Your Honor. I'll try to be slower than usual, at least. On the point of cumulative error, so we address in our reply why we think cumulative error applies, notwithstanding the government's technical argument about the difference between a IEC posture and a direct appeal. But even if the government is right, that reinforces prejudice on the Fourth Amendment, because had the Fourth Amendment argument been raised and considered as a direct appeal claim, then cumulative error doctrine undoubtedly would apply. You'd have the Fourth Amendment suppression issue and you'd have the exclusion of evidence. So if the government is right, that it all kind of comes out in the wash as another example of prejudice. Hope that was probably a medium-length sentence for me, but I thank the court's time.
Thank you. I thank both counsel for your briefs and your arguments today. Our third and final case is In Re LC.
Good morning, may it please the court. Daniel Gunan for the appellant LC. I'd like to reserve 2 minutes for rebuttal. Given the limited amount of time, I would like to focus today on the first two issues in our brief, though I'm happy to answer questions on the latter two issues. And beginning with the first issue, which is the reasonableness of the purported second shot. This is a case where Judge Salerno found
I'm sorry, the reasonableness of
the supposed second shot, assuming it happens at the 7:37 mark in the videos. Judge Salerno found that almost everything LC did during this incident was justified, including picking up the
Can I
gun.
ask you that? I want to start with that premise because
Okay.
I'm not sure I share it. So
Okay,
Judge Salerno, at least as I was looking at the record, pretty consistently, carefully said something different from what you just said
okay,
and said, I can't find beyond a reasonable doubt that the conduct was unreasonable.
right.
That seems different from saying, I actually view this as reasonable. And the reason I think it's different is because your point is sort of, how can you think something's reasonable and in the middle of this chaotic scene shift over to criminally unreasonable in 2 seconds?
Right.
And that's a fair line of, it's
Yeah,
a fair line of concern. But if instead what the trial court is saying is first shot, and this is not exactly what the trial court said, but just in terms of what you could more concretely use to fill in the trial court's wording. The trial court's thinking, that's pretty close to the line. I'm not sure that was okay, but I can't find beyond a reasonable doubt that it's criminal. To get from, barely non-criminal over to criminal in 2 seconds seems not that hard. And so I do think it's an important starting point of your argument that I'm not sure I share yet.
Okay.
To think of it as the trial court blessing the first shot and then sort of incomprehensibly, unreasonably condemning the second.
Right.
So I'd like to just tee that up for you as a topic.
Okay, fair enough. I mean, yes, he says it hasn't been proven beyond a reasonable doubt. I mean, that is the standard. So he's applying there is no other preponderance of the evidence standard. The defense doesn't have to prove it was reasonable.
Of course not, but a judge could certainly say in returning a verdict,
Yeah.
I actually think that shot was fine.
Right.
That's a totally reasonable thing that was done. I endorse it.
But then,
But the judge did not do that, I don't think.
okay.
Do you
and he-
agree with that? At least the judge did not endorse the first shot in the sense of saying, I am finding that that was that was entirely reasonable. I support that first shot. And then all of a sudden I have these unreasonable expectations of how the defendant should have transformed the situation in his mind or the respondent should have transformed that in the preceding 2 seconds. I don't think
Agreed.
the trial court did that.
I agree that the trial court did not do that. But what the trial court did do is he said, even when the second shot is fired, and with the caveat that it's under the proof beyond a reasonable doubt standard, so that's how he's articulating. Even at that point, he can't say, I guess you could say, interpret his verdict as saying, I'm not prepared to say to the requisite level of certainty that even at that point, LC did not perceive that Mr. Bryce Hayes is in danger and that lethal force was necessary. And he even goes so far to say, is like, I don't even think, or I can't conclude that he had even formed the intent to kill, right? Which can happen at the speed, can happen instantaneously. But even in that moment, he says, I don't think there's intent to kill, or intent to kill hasn't been proven because it's muddled by his fear and this imperfect defense of others. So given, when you take the constellation of findings, the question is, has the situation changed in that, 1 to 2 second period when everything is in motion, everybody's moving around, his view of Miles is momentarily blocked? Is there enough change in that brief period of time to say that, well, I don't think it was reasonable, or I can't say it was unreasonable, and I can't say he didn't believe deadly force was necessary, but because I can see from my purview as the judge that Miles now has his back turned to him, although he's, Mr. Miles is moving, he's rolling to get up, and I can see that he's not holding, yes.
Can I interject here with the overarching issue challenge that I'm having here about, standard of review and our viewpoint here.
Yeah.
We have the video, we have the frame by frame photos.
Yes.
It's a very short snapshot in time.
Yes.
We have what I had been viewing as Judge Solano's finding that the second shot was unjustified.
Yes.
Because of what Judge Solano sees.
Correct.
So how do you view our role here? Can we substitute if we think, I didn't see that shot, I don't know what he was talking about. We have to find he was clearly erroneous. Are we looking at this completely de novo and completely substituting our judgment on the whole sequence?
Right.
How should we be viewing that?
Understood, Your Honor. So I think this is a case where I think the parties agree we have factual findings on the material factual issues, including subjective belief and intent. And we cite in our reply brief, the question of, given the state of facts, was the use of force reasonable, is a question of law that's reviewed de novo. This court said that in Gay, citing Fersner. So that is a de novo question. The question of whether he fired the shot as opposed to just pointing the gun at 737, that I agree is a factual issue. So the judge gets deference on that, but there is no evidence to support that there was even a shot fired at that moment, as opposed to the gun just being pointed.
Can I ask you about the first half of your answer,
Sure.
where you said the question of if you take all the historical facts
Yeah.
and you determine whether the label reasonable should or shouldn't be attached to it, that's reviewed de novo.
Right.
I'm not sure. I think our cases about sufficiency review and de novo are kind of confusing.
Right.
The question of sufficiency is treated as a de novo question. But on the other hand, it's also treated as something where we have to defer to the prerogatives of the fact finder. So it's sometimes it's de novo relative to a trial court's motion for judgment of acquittal ruling, which is also similarly deferential.
Right.
Are you saying that if we have in a bench trial where the trial judge says, I find historical facts 1 through 17, and I find that the exercise of force here was not reasonable self-defense,
Right.
that we owe no deference to the trial courts as a fact finder, as a verdict renderer, ability to make judgments about what is reasonable, and we decide ourselves what would I have done if I had been the trial court? I hadn't understood our law to be that. So if you think that's our law,
Well,
I would like to be.
Gay says that, which is cited in our report.
I'm sorry?
The case Gay, the United States says that. Maybe I'm getting the name, misremembering the name, but it's cited in our reply brief. There's a case that says the reasonableness of the use of force is a question of law that's reviewed de novo. And if you look at cases we cite like Cave, but also Williams and Parker, those are all cases involving reversals where if you just view the evidence if you disregarded the trial court's findings, they're all bench trials where the trial court's makes findings. And those are all cases where you might say, if you ignore the trial court's findings, there would be sufficient evidence to convict. And so the case would be affirmed. But we take the trial court's findings and then we ask, did the trial court make some sort of legal error that warrants reversing, or factual error? But I think in those cases, it was generally a legal error that warrants reversal of the ruling. So you could look at the case.
So let me be,
Yeah.
slightly hypothetical, and it serves two functions, I guess, partly to illustrate the standard review, but also it's a question I had independently of that. Imagine the trial court had responded here to this, had found the facts as the trial court found, as purely historical facts, but had said, I am going to find guilt relative to the first shot. Because I think that was unreasonable force.
Yeah.
Because at the time the first shot was fired, the defendant is unarmed, apparently lying on the ground, and there's no immediate threat to anybody. And so it was just not reasonable to use deadly force at that time. It would have been reasonable perhaps for the respondent to have waved the gun and said, stop or I will shoot you. And so threat of use of deadly force might have been reasonable, but this shot was not. Would you say that, first of all, we would review that de novo? We would say, well, it's interesting what the trial court thought about that, but that's equally for us to decide, A. And B, either, whatever your answer is to that, would you think as a matter of law that would have been an impermissible verdict?
Well, the answer to the first part of your question is I understand the case law to say the pure question of reasonableness, given a set of historical facts, including intent and subjective belief, that is a question of law reviewed de novo. As reasonableness generally is considered a question of law. And, if you look at even the federal courts of appeals cases we cite, which are all summary judgment cases, and they're saying this is objectively reasonable as a matter of law. It doesn't matter what a fact finder might think. So you could view this case as where, given the set of fact findings, it is reasonable as a matter of law. And the conclusion of the contrary isn't supported by the findings or by the record. The other question you asked was, what if the judge found the first shot was objectively unreasonable? Well, then I think there's a whole different set of arguments about the use of force being justified to prevent the completion of a forcible felony, which was raised below. We haven't argued that on appeal because I think it kind of falls out of the window when the judge finds the first shot is justified. So, I mean, I don't know if the judge said, I think when he fired the first shot, he subjectively believed that deadly force was justified, or he did not subjectively believe, that would obviously I think that would be beyond sort of appellate review. But we have the opposite findings for both shots on the subjective intent. And there's ways you can think about this case as being error of law and error of fact cases, or this being an error of law or an error of fact. The error of law being he does, articulate that when he goes through his sort of like analysis of legal principles, he articulates the principle about heat of the passion. But I think when you actually read his findings, he's saying, well, I can see that Mr. Miles has his back to LC at this particular moment when the second shot is fired. And I can see that Miles has lost his grip on Bryce Hayes at that moment. But he's looking at the almost 180 degrees different view than the view that LC has. So LC can't necessarily see that, and he doesn't find that LC sees that. And his finding is essentially, well, I don't know what LC believed. I can't say beyond a reasonable doubt that he had perceived, or there's a reasonable doubt as to what LC subjectively perceived. There's a reasonable doubt as to what he processed in that moment under the heat of the passion. And there's a reasonable doubt as to whether he had enough sort of reaction time to, once he's in motion of, I need to use defensive force to save this person, whether he's able to, see suddenly in a fraction of a second, what I thought was happening is no longer happening. I'm going to desist.
Some of your comments there and some in the brief suggested an argument that is potentially to a degree distinct from a sufficiency argument, which is the trial court here sort of lost focus on the right legal standard.
Mhm.
Although, I mean, the trial court did sort of instruct itself, and it did
Yes.
have some of the general language that would be the right framework about heat
Right.
of passion and all of that. But at times, some of your comments are, when you get into the nuts and bolts of the trial court's reasoning,
Uh-huh.
it sort of doesn't seem to always keep focus on the idea that it needs to be situating itself in the respondent's real world situation and with the limited information the respondent might have.
Yeah.
And so if one thought that was something that was happening,
Mhm.
that might not be an impediment to sufficiency of evidence. That might be a problem with the trial court's reasoning and returning the verdict. And it might, in the alternative, warrant a remand to say, there are times, trial court, where it seemed like you weren't really focused on the exact framework you should have been. But I hadn't understood your brief, at least specifically, to raise the idea that there's a problem with leaving aside sufficiency. In addition to sufficiency, there's a problem at a minimum that the trial court has kind of lost focus on the legal standard. And if sufficiency isn't resolved in your favor, at a minimum, there should be a remand to tell the trial court, try it again with a more realistic, appreciation of the actual context in which the respondent was, including what he could see or what you can conclude he could see and the like. Am I right that that's not an express request in your brief?
Well, we certainly didn't ask for a remand, so that is definitely not a request. I think definitely our brief, I don't know that we broke it out, or we didn't break it out separately. Here's a sufficiency argument and here's a, the judge misapplied the law kind of argument. I'm not sure really how separate those are necessarily at the end of the day. Our view is this is a bench trial, so we review the sufficiency of the evidence given what we know about the trial judge's factual findings. One thing I don't think the trial judge ever said is that I consider objective reasonableness based on the subjective perceptions of the person in the moment. I could be wrong about that, but I don't think he ever articulated that principle from Fersner. And given the fact that he's saying, I at least have a reasonable doubt that LC had perceived that the threat was over, I don't know how you can say, but as a matter of law, even if he may have perceived that the threat was still going on in this very short amount of time, when everyone is moving and it's chaotic and frenetic and he's in the heat of passion, I can say, oh, now at this point, it's objectively unreasonable. And since I'm almost out of time, I do want to touch on two other things, which I think are really just narrower factual issues, but in a way much simpler than this kind of legal question. So number one is Judge Salerno makes the finding on page 20 of the record that I'll call him Officer McGee, given the technicality that he's not licensed, but that's not super important right now. But Officer McGee is firing at LC after the first shot that LC fires. So and he kind of analyzes the shots he analyzes the two issues separately, right? There's a set of charges against Officer McGee and a set of charges against, or a set of charges where McGee is the complainant and a set of charges where Miles is the complainant. And it's on A20 of the record, this is actually very important because on page A19 of our appendix, page 19 of our appendix, Judge Salerno is saying, I've got this problem because in assessing self-defense for the shots fired against Officer McGee, I've just made a finding that the first shot was justified and the second shot was not. So now I have to consider provocation and whether LC forfeited self-defense for the shots fired against Officer McGee because he fired that second unjustified shot. And that's at 8:20, he makes that finding. Well, Officer McGee started firing at LC after the first shot, not the second. So that's important potentially to his provocation finding. And then he goes on because the government had argued that when LC turns to run up the escalator, the gun was briefly pointed at Officer McGee. And he says, but then LC is retreating and Officer McGee continues to shoot him in the back. So he says LC has his self-defense claim. So we have a finding, an express finding that Officer McGee fired after the first shot, before the second shot.
There also is a contradictory finding, is that correct?
There is a contradictory finding at the very beginning. He's going through, I mean, it's contradictory only in the sense that he throws out a timestamp that I think is wrong.
I thought I may be misrecollecting. I thought in addition to the somewhat confusing timestamps given uncertainty about synchronization.
Yeah, but he says at 7:36, you can see that Officer McGee.
Then I thought he said something about after or so, but I thought there was a term, not just timestamps.
He says around the same time or shortly after the first shot. So that is significant. He's not saying that, he's saying that for a reason.
Can I ask you a question?
And what's the consequence of what you just pointed out?
So,
That
right.
the court found that
So
that
if
McGee fired before the second shot?
So that means at the moment, when Elsie has just fired a shot that is at least not beyond a reasonable doubt unjustified,
Right.
now someone else is shooting at him. And Judge Schlerner does make the express finding on page 21 of the appendix. Elsie does not know who's shooting at him. So all he knows is, I've just fired a shot that I justifiably believe is necessary for self-defense. And now I'm hearing gunshots. Somebody is now shooting at me.
How do you know he doesn't know who's shooting at him? How do we know that?
There was evidence. So there was one of the officers, it's on body cam, and there was a little bit of dispute about its admissibility, but it's on body cam that an officer asked him, "Do you know who shot you?" He shakes his head no. And Judge Schlerner does expressly make the finding at 821. He didn't know, and I think that's further
Well,
supported.
that's different he though, right? That's
Sorry?
the officer not knowing who was shooting him. I think Judge Thompson's question is about how do we know what Elsie knew about who was shooting at Elsie?
Yeah, the officer asks LC, "Do you, LC, know who was shooting at you?" And he shakes his head no. And that is eventually admitted over a hearsay objection. And then Judge Schlerner makes that finding. And even if you didn't have that testimony, you can see on the video, LC never looks over at Mr. McGee.
Part of the reason for my question
Yeah.
is that what we see in the video is, I know that you dispute that there was a second shot. Maybe
Yeah.
he just pointed the gun.
Yeah.
But he's not pointing it away from Miles, is he? He's not pointing it at either of the special police officers or
Yeah,
purported special police officers.
And I think that's consistent
Right.
with, he may not even know they're special police officers because they're wearing orange vests that.
Right.
There's
So there doesn't seem to be an argument that he's shooting at them when he fires the.
No, that's
purported
correct.
second
So
shot.
the point is, in that brief moment, in the heat of passion, when he has just justifiably fired one shot. Now, and Judge Schlerner is saying, but things have changed because I can see things in the video that tell me Mr. Miles is no longer a threat at that point. But what he's not accounting for is now somebody else who Elsie doesn't know who it is, and Elsie can't see Mr. Miles' hands because Mr. Bryce Hayes is blocking his view. But now somebody else is shooting at him. I guess maybe he doesn't know it's at him, but he hears gunshots, and it's reasonable for him to think in that split-second moment that he is still in danger because now there's another shooter, there's another gun that he can't account for. And so he does think in that split-second moment, I'm still in danger now from a gun.
But if he did think that, that would not be a justification for shooting again at Mr. Miles, correct?
Well, if he's, again, in that split second, he can't see Mr. Miles' hands. He doesn't know who's shooting at him, an express finding by the judge. So I think there's at least a reasonable doubt that he would think, well, the person who's shooting at me is probably the same person who was just trying to, kill or seriously injure my friend. Maybe he had his own gun that now he's pulled out and is shooting, so I need to shoot him. Mr. Miles is the only person that Elsie ever perceives as a threat. And you can see in the video the whole time, he's laser focused on Miles. He's never looking over at Mr. McGee. Even when he's running up the escalator, this was another factual dispute, but he's looking over his right shoulder and pointing behind him. And the gun in every single one of those still images we put in our reply brief is pointed directly at Miles, never at Mr. McGee. He never even looks in that direction.
Can I ask a question
Yeah.
that relates to Chief Judge Blackburn-Rigsby's standard review question, which I started trying to look into this and then lost focus on it. So maybe you can help me off the top of your head, or maybe your colleague can. Is it clear from the record whether the judge as fact finder had the capability of, had the videos and, could view them and stop frame in the way that the briefs do, or could slow them down, or is it just clear what technological opportunities the judge as fact finder had to look at the materials at issue?
Well, he definitely had the videos. Like, I believe after the closing arguments, he asks, have all the videos been uploaded? And he does say at one point, I'm going to review all the videos very carefully. I can't tell you what kind of software he had to view them with, but I think it's a reasonable inference, especially when he's throwing out, some timestamps that may or may not be right, but he's at least pausing it. And I think, for him to be able to say, oh, at 7:37, I could see that Mr. Miles is no longer holding on to Bryce Hayes where he was a second earlier. That's something you can only get really from pausing the video. If you watch the video one time through, you're not going to pick up on any of that kind of stuff because it's all happening so fast. It's so chaotic. There was one other factual point I wanted to raise, which is on the second shot, that there just isn't evidence that shot happened at 7:37. And, I think that's addressed in our briefs if the court has any questions about that point, but I think that is in a way the narrowest way to resolve this case because there's just no evidence the shot was fired at that point. I think the testimony actually contradicts that. And I didn't get to the second issue, which is the attempt issue, but I see my time has expired. So unless the court wants me to talk about that, I'll sit down.
I guess I have at least one question about
Okay.
it, which is, I mean, I think the parties would agree that we have conflicting lines of authority and there are questions about how to resolve them.
Right.
And so I have essentially a stare decisis question, because I think your presentation rests on the idea that this issue got resolved definitively in old cases.
Yep.
And I'm unsure whether the old cases do resolve the question, and for two reasons. I just want to flag them and get your response to them.
Okay.
One of them is that some of the old cases will say things like, in order to commit an attempt, you have to have the intent to commit the crime.
Yes.
And it seems to me that you're construing that old language in a way that assumes that the word intent, when used there, means purpose as we understand it in kind of more modern, model penal code frames of thinking. And it seems to me that it's a little unclear to me whether that's a fair assumption, given that there's a lot of case law that throws around the word intent as a synonym for mens rea rather than, being equivalent to purpose. So that's one concern.
Okay.
The second is a question of kind of specificity of analysis. And one could take the view, arguably, that the first time we have a holding on the question of how does attempt work with offenses that don't require purpose or something like it, we don't have a holding on how to handle those issues until somebody realizes, oh, wait, we have an offense where there's that discrepancy, and now we have to figure out what that means. And before then, if we're throwing language around without confronting that feature of the situation, it's just not a holding on that feature. And if that's the second line of thinking, I might point us to a different view about what our, the first holding is that would govern, barring Supreme Court intervention. Okay. So I just wanted to throw those two concerns out and get a quick response from you about them. Or relatively quick, moderately quick.
Okay.
I don't mean to be suppressive of a full answer, but.
All right. I'll try not to be as wordy as Mr. Lipper was. Okay. So let's go back to Sellers, which I think everyone agrees is the first DC case that matters. Sellers expressly holds that the intent to commit the offense in the sense that I mean it is required for attempt. And I'll explain why it holds that. Sellers, the offense charged in Sellers is attempting to arrange for sexual acts in exchange for money. So attempting to arrange acts of prostitution. And the defense at trial is the defendant says, well, it was a trick. I was going to take these guys' money and then I was just going to leave with their money. I never actually intended for them to engage in any acts of prostitution. And this court says, well, for the completed offense, all you need is an arrangement. You don't need to actually produce the prostitution. You just have to have an agreement. And so they say, had he actually received any money, this would have been a completed offense, regardless of his intent. But then they go on to say, well, the intent for attempt, you have to have the intent to commit the crime. And they say, whether defendant actually was making the arrangements forbidden by the statute or whether he intended to vanish if he obtained the money was a question of fact, which the trial judge resolved against him. We think there was ample evidence to support such a holding. Accordingly, the judgment must be affirmed. So that is a holding that the government satisfied a burden that it had to prove this intent. Now, I understand the court could have said, well, we don't think the government was needed to prove that because they don't need to prove it for the completed offense. But that's not what the court held. The court held this is an element and the government proved it beyond reasonable doubt. And that is a holding that binds this court. I think Wormsley is the same, essentially the same. And Judge Beckwith in her Jones concurrence talks about Wormsley and how important it is that for taking property without right, the completed offense, you don't have to actually have any kind of intent to steal. You can think it's yours. You can think you're the rightful owner and still be convicted of completed taking property without right. But she explains that in Wormsley, for the attempt to take property without right, the court really focuses on evidence in the record that there was an intent to steal, that this woman had kind of folded this dress up in a clothing store and stuffed it in her sweater. And so then she puts it back on the rack, so she doesn't actually take it. But they say, given that evidence, there was sufficient evidence of attempted taking property without right. And I think even Marginella Well, it's maybe not as clear. It lists the elements of false pretenses, the completed offense, and then it says, however, the elements of the crime of attempted false pretenses, like other attempts to commit a crime, are an intent to commit it. And we hold that the trial court could find beyond a reasonable doubt that appellant intended to commit and performed an act towards the commission of the offense of false pretenses. So I think all those cases are holding this is an element, the government, and we're affirming the conviction because the government presented sufficient evidence to prove it beyond a reasonable doubt. Now you have Smith come along. And what is even the holding of Smith? Well, I think this holding of Smith could be read quite narrowly. It says, when an attempt is proven by evidence that the defendant committed the crime alleged to have been attempted. So in other words, when you prove the attempt by proving the completed offense, in that scenario, the intent required to commit the crime of attempt can be no greater than the intent required to commit the completed crime. And then it says, we hold that proof of the crime of second-degree cruelty to children, the completed crime, is sufficient to convict a defendant of attempted second-degree cruelty to children. So that could be read as a holding that under Rule 31, if you prove all the elements of the completed offense, then a judgment on the attempt is permitted on the theory that you've proven the completed offense, and attempt is generally going to be a less serious offense. So, and it seemed to be permitted by the literal language of Rule 31. In this case,
The idea behind that would be that the elements of the attempt offense change depending on whether proof of a related but different offense, an element of a related but different offense was met. I mean, it'd be a pretty strange doctrine.
Judge Beckwith says that, essentially she says that in footnote 4 of her Jones concurrence. So I'm not prepared to endorse that as a good rule of law. I'm saying it seems to be what Smith is saying, is that when in this situation where the completed offense was proven, every element of that offense was proven, we're going to permit a judgment on the attempt as sort of it's not prejudicial to the defendant because they're being convicted of a less serious crime. The government proved everything we needed to do to get the more serious offense of the completed offense. But certainly it wouldn't apply to a case like this where, the government failed to prove that there was a killing. So given the two lines of authority, given the sort of narrow way Smith seems to be written, we also, in our reply brief, talk about the difference between result offenses and conduct offenses. The bottom line is, I think, that every court in the country, including the US Supreme Court, has said for a homicide offense, attempt requires the intent to kill.
I'm not sure it's true about every court in the country. You might want to check Florida, but for sure many. So I'm not quite sure.
Well, every case, I'm not aware of any Florida case. Obviously, you may be aware of something I'm not. Certainly in the universe of cases that's been cited, and I would say overwhelming authority, including US Supreme Court authority, says you need intent to kill for attempted homicide.
I apologize to my colleagues for this, but relative to Supreme Court authority, do you have a view about whether the statement in the footnote in Braxton is dicta or holding? Because the issue in the case was about an offense that required intent to kill, and so intent, the issue of how to do attempted murder really was not germane. They, to the issue the court had to decide. So they cited an authority that addressed a related but distinct kind of homicide. So why would you say that footnote is a holding rather than dicta?
Well, so it's a little bit of a roundabout way because it comes up through this guidelines issue, but they're saying the judge sentenced the defendant, Braxton. He pled guilty to a lesser crime, but the guidelines say you can sentence him based on the most serious crime that his acts establish. And the judge said, well, the most serious crime his acts establish is attempted murder of a federal marshal under, I believe it's 18 USC 1114.
I thought it was attempt to kill a federal marshal.
Sorry, yes, attempt to kill a federal marshal, yes.
Which will require then the completed offense.
It says whoever kills or attempts to kill.
Right.
So if you say, well, and they say, what does the word attempt mean? And they say when Congress uses the word attempt in the statute, it incorporates the common law understanding of what attempt meant, which meant that you would need to have the intent to commit the specific offense, which in the context of homicide means you have to have the intent to kill. And they say, in the plea, Braxton never stipulated that he had the intent to kill, so that the stipulated facts did not establish a violation of 18 USC 1114, and therefore it was error to sentence him on the basis of him having committed that offense under the guidelines. But it's a statutory interpretation case based on what the word, when Congress uses the word attempt, what does Congress think attempt means. It means the common law, which requires the intent to commit the offense, which in the context of homicide requires the intent to kill.
Can voluntary manslaughter in DC be established without establishing the intent to kill?
It can. The completed offense absolutely can. That's not disputed, but.
So
and the
doesn't
thing-
it seem a bit in tension with the notion that if the completed offense can be proven without proving the intent to kill, then the attempt can be proven without proving the attempt to kill?
It's not.
Intent, I'm sorry,
Yeah,
I said attempt.
because the attempt has the elements of attempt are not the same as the elements of the completed offense. You have this additional requirement that you have to intend to commit the completed offense, which for a homicide is you have to have the intent to kill. So, all the cases we cite in our opening brief are cases from various courts that have said, yes, it's true that to commit, their version of voluntary manslaughter under their state law, absolutely you don't need to have the intent to kill. It can be a conscious disregard of a substantial risk. But if you're charging attempt, that changes it, because how do we separate, inchoate offenses that from just sort of bad thoughts or.
Like there's some disconnect though to require essentially a higher standard of proof for the attempted offense than you would for the completed offense.
Yeah, so it's different. So you don't have to, obviously for attempt, you don't have to prove that the crime was actually committed. So you don't have to prove there was a killing. You don't have to prove, in Sellers, they didn't have to prove that there was an exchange of money as would be required. And in Wormsley, they didn't have to prove that property was actually taken. So there's a lesser element in some sense, but the sort of flip side of that is you have to prove that what the person was intending to do was to commit the completed offense. And as we say in our reply brief, imagine attempted homicide doesn't require intent to kill. Then that would mean that, throwing a punch at someone, even if you don't hit them, which would ordinarily be simple assault, right? But the government could say, well, if the person had died, then we would be able to argue that there was some degree of mens rea that would correspond to some degree of homicide, whether it's voluntary manslaughter or involuntary manslaughter or second-degree murder. So every time you throw a punch, now the government could charge that as attempted homicide. Or every time somebody's convicted of driving under the influence, under circumstances where if they hit somebody and killed somebody, it would be some form of homicide. But now every DUI could be charged as attempted homicide. And that's clearly not what the law is, because the law says we have to draw a line somewhere when we're charging people with these inchoate offenses like attempt. And the way we draw that line is there has to be proof that the person intended to commit the completed offense. That's what this court has held in the cases we cite. It's certainly what the Supreme Court held in Braxton and even in Bailey, which is the case that's cited by Bronner.
Well, that's what this court has held in one line of cases, but I think the dissent in Jones talks about the diverging two different lines.
And that's why we cite Thomas, which is very clear that when we have, assuming you think, the court thinks that the Seller line and the Smith line are irreconcilable, then there's only one thing the court can do: apply Sellers, because that's the first line. That's what Thomas says. That's how this court has sort of precedent on how to deal with conflicting precedent. And under that precedent, our position prevails.
All right.
But
you
I
want to reserve the rest of your time for rebuttal, Mr. Goldman. Thank you.
Thank you.
Good morning, and may it please the court, Jeremy Girton for the District of Columbia. I'd like to start with the attempt issue that the court was just discussing with my colleague. And I agree that this is a difficult question of law on which there is some tension in this court's cases. So I think the easiest way to resolve this issue is to recognize that this issue was at minimum forfeited, if not waived, by LC in the trial court. And if you look at the motion for a judgment of acquittal, and that's record 642 on the second page of the motion, LC laid out what he thought the elements of attempted second-degree murder are. And he acknowledged that attempted second-degree murder can be committed with one of three mental states. So he did not argue below that you need a specific intent to kill in order to commit attempted second-degree murder. And now his position on appeal is completely opposite. That specific intent is a necessary element of attempted second-degree murder, and attempted voluntary manslaughter. So I think at a minimum, that is a forfeiture, if not a direct waiver of this issue. And since this issue has never been decided by this court directly, on plain error review would not succeed.
It seems, I'm not sure it's never been decided as opposed to have been decided for various offenses in conflicting ways, which, you know, it may be still, if the plain error standard were applicable, might be sufficient for your point. But we have some pretty lenient and special rules for preservation of sufficiency of the evidence in bench trials. And so can you address whether you think any of those principles excuse the failure to make a specific objection in the trial court, or you don't think they do?
We don't think they do. And I think the most applicable case is the Jones case, which was a bench trial case. And this court assessed whether attempted threats require specific intent. And the court analyzed that under the plain error standard. And then it separately analyzed sufficiency questions de novo in a separate section of the opinion. So we think that's almost exactly the same legal issue here. And the court was applying the plain error test in a bench trial.
Can I make sure I understand what you're saying? Are you suggesting that if the claim is one of legal error, that the trial court should have required an intent to kill for the attempted, what turned out to be attempted voluntary manslaughter, we would apply plain error to the judge not having the right element in mind? But then you seem to be suggesting that we wouldn't apply the plain error standard to determine whether, measured against the correct elements, which if we were persuaded by the argument would be intent to kill, there was sufficient evidence. Or when we could move to the sufficiency side of it, do you think we still operate from the assumption that what was required was only what the trial court thought was required, and as to which nobody had argued otherwise? I don't know if my question is a little convoluted, but if you follow.
No, I think I understand the question. And I think that's right. There's a division between kind of the legal framework, what are the elements of the offense, for which I think plain error review would apply. And then there's kind of the separate question of, is there sufficient evidence to meet all of those elements?
Properly understood. The elements properly understood. Well, if you acknowledge-
sorry, it depends on kind of the outcome of the plain error question, right? If you conclude that it wasn't plain error, then I think you would apply the elements as the trial court stated.
I see. So but you would, if the court said, for example, in a bench trial, everybody agreed that the offense had 3 elements and nobody focused on the 4th. And now the defendant is arguing that there was legal error in that there is a 4th element that everybody missed, and the evidence isn't sufficient because there wasn't actually proof of that 4th element. If you turn to the first issue, and which is what are the actual elements of the offense, and the court says, well, that wasn't raised in the trial court, we're going to apply the plain error standard. Let's say first, it was error. I mean, that's the thing we could do. We wouldn't necessarily have to. We said it was error. Actually, there are 4 elements, but B, that wasn't obvious. I guess it would become obvious. So maybe this is, you would say, I think the way it would spin out, if we decided it was error, and that would make it obvious for purposes of the plain error standard in that direct appeal, then you would say we would then figure out whether the defendant could show prejudice relative to the plain error standard. And then when we went to sufficiency, because we had said it was obvious error, we would measure the evidence as against what the elements obviously should have been, rather than what people incorrectly thought at trial they were.
I think that I agree with everything that Your Honor just said, but
Which I think means that if we thought your opponent was obviously correct, then the evidence is either insufficient or something very similar to it, because the trial court did here expressly say, I can't find beyond a reasonable doubt that there was an intent to kill relating to the shot that's the predicate for this charge. So even if the evidence might have been sufficient, we would have had a finding from the trial court that the trial court wasn't persuaded by it. And so
Right.
I think that means if your opponent is obviously correct, you think he would be entitled to prevail on a sufficiency type theory, that the trial court viewed the evidence as inadequate, and that'd be like an acquittal of it.
Right,
But your
right. I
argument is the
think
trial
that's
court-
right. I think the trial court made a finding about the subjective intent that I think would preclude
Right.
that,
But the flip side, just to make sure I understand your position, it's a little convoluted, not a criticism, the area of law is convoluted. The flip side is you think that if we look at the legal component of your opponent's argument and say, well, it's kind of a mess whether assault with intent to kill is required for attempted voluntary manslaughter. If that's not obvious to us, then the defendant's going to lose on that part of it as a claim of legal error. then you
Right.
would say, when you go to the sufficiency evidence, take the evidence, we won't know whether these are the right elements or not, but we will just say, these are the elements everybody was working with in the trial court. It's not obvious they were wrong, and we're going to measure the sufficiency of the evidence as against the elements as understood in the trial court.
Right. I think that's what the court did in
And-
Jones, and I think any other rule would kind of allow you to backdoor challenge to the elements through the sufficiency after already acknowledging that it wasn't plain error. So I think if it doesn't meet the plain error test, then the elements are just not in the.
I understand that line of thought, but it is a little difficult to square that line of thought with some of our views, which say things like in a bench trial, you put you put every issue in by pleading guilty. And so you can, let's say everybody understands what the elements are, and the defendant, doesn't ask for a motion for judgment acquittal, doesn't ever say to the trial judge, by the way, there's evidence missing, all that. We excuse all of that and just try to figure out whether the evidence was sufficient under ordinary review standards. So we excuse a lot of failures to raise specific claims that relate to the sufficiency of evidence in bench trials. And, again, one could try to figure out how that all is rationalized together, but it does seem that's a little more stringent than some of the doctrines we applied in this general area.
So I would agree that the automatic preservation rule does allow the defendant to raise a lot of issues on appeal that maybe weren't touched on in the trial, but they're all about kind of the sufficiency of the evidence, the factual issues. And the point of that automatic preservation rule, as I understand it, is that by pleading not guilty, the defendant is contesting that there's sufficient factual evidence to prove all of the elements as stated by the court. And we don't need the defendant to specifically object to each of those in order to have it be an issue that the trial court could potentially correct during the course of the trial. But when you're talking about the legal elements of an offense, that is something that a timely objection could allow the trial court to correct, and then they could apply the correct legal standard to the facts as they find them. And I think in this case, where you have a written motion from the defendant laying out what he thinks the elements are, and one of those on the mens rea point, he says you can commit this crime with one of three mental states. That is a pretty clear invitation for the court to apply that legal standard. And then on appeal to say, no, the trial court should have realized that the only way to commit attempted voluntary manslaughter or attempted second-degree murder is with specific intent to kill, an argument that was never raised to the trial court at all. I think that's really different than the kinds of issues that the automatic preservation rule is intended to preserve, because it's a real legal question about which there's a lot of disagreement, and the trial court didn't have the opportunity to really address what the proper standard was, other than to accept the legal framework that the defendant put forward. So
It's an analogous situation where the defendant did not raise as a defense that the statute under which he's charged is unconstitutional, but then on appeal says the statute is unconstitutional. I mean, we've had those cases, and what have we done with those? We haven't said automatic preservation, have we? Because the defendant pled not guilty.
I confess I'm not sure about the answer to that
I'm
question.
thinking of this as I sit here too, so I'm not sure what the answer is
I'm
either.
not sure about that, Your Honor. But I would think it would be somewhat akin to a legal error, because it's kind of a purely legal question about the constitutionality of the statute, but I don't know how the court has treated it in the past. But on this particular issue about whether an attempt requires specific intent, in the Jones case, that was directly presented and the court analyzed it under plain error. So I don't know why it would have done that if this sort of error is automatically preserved by kind of the automatic rule for sufficiency. So I think the easiest way to resolve this conflict is on plain error or forfeiture. But even under de novo standard, I think we prevail based on this court's cases describing attempt as always a lesser included offense to the completed offense. And Judge Blackburn-Risby, as you stated, it would be kind of incongruous to say that the mens rea is necessarily higher for an attempt than it is for the completed offense. And I think that's the intuition that has driven some of this court's cases. Particularly, I would point to the Fry case, because that was a case in which one of the elements of the completed crime, aggravated assault, is bodily injury, substantial bodily injury. And the court said you don't need specific intent for that result in order to get an attempt conviction. So it's exactly the same situation as here, where we have a result element of the completed crime. In this case would be death of the victim. In that case was substantial bodily injury. And the court said because the completed crime could be committed with a recklessness mens rea, attempted crime is the same. We apply the same mens rea elements to attempt and completed offenses. And there's no way that that case could be right under the rule that they're proposing, because then you would have needed to have a specific intent to cause substantial bodily injury, and nothing in that case says that there was evidence of that in the record.
Can I wrap back around just on the issue preservation point? You're talking, the Jones case you're talking about is the 124A third 127 case. Am I oriented correctly? Because there are a couple of Jones cases.
I think there's a couple Jones cases cited, so I want to
Right,
make
that's
sure I'm right on which one we're talking about, but it's the attempted threats
Yeah,
case.
Seems like the claim there was a little bit different from the claim about the elements of an offense. I thought the claim was the defendant is saying this, I was prosecuted for a thing that doesn't exist. And he
Right, and
said, that's
I
a plain error kind of point.
right, I think there's I recognize a slight distinction there, but I don't think it's a distinction that really matters for this purpose, because it's essentially the same argument about there can be no crime with these elements because you need this specific intent that can't exist for attempted threats. And here they're saying you need this specific intent, which wasn't found in this case. So I agree, it's a slight variation on the facts, but I think it's really analogous to the same type of legal error that wouldn't be covered by the automatic preservation rule. But I did want to address your point, Judge McLeese, about kind of the what is the first in the line of cases addressing the attempt issue. And I just don't see in either Sellers or Wormsley a clear holding that gets them to where they want to go. I see a lot of language about kind of generally you need to have the intent to commit the underlying crime, but I don't see anything saying that means you automatically ratchet up the mens rea of the underlying crime to specific intent. So I think the first clear holdings on this issue come from the Ray case, which holds that a completed offense necessarily includes an attempt. That obviously can't be true for many offenses that could be committed with a recklessness or some other lesser mens rea. And then the Smith case, attempted cruelty to animals, where the court said, that can be committed with a recklessness mens rea. So the attempt can also be committed with that level of intent. So I think those cases really foreclose the issue. But certainly this is not one that would rise to the level of plain error if you're applying that standard. I also wanted to address the point my friend on the other side made about the District of Columbia being an outlier. I think, as you pointed out, Judge McLeese, Florida is on the same side as the rule that we're proposing here in the Williams case, which is 123 Southern 3rd 23. I also think really directly on point is Colorado in the Thomas case, which is 729 Pacific 2nd 972, which directly addressed the exact same offense here, attempted voluntary manslaughter, and said, yes, it can be committed with a recklessness mens rea because the completed offense can be committed with a recklessness mens rea. So we don't think the other states really.
I'm not sure that has gotten us out of outlier status. If you've identified two cases that it's two jurisdictions that go that way, do you dispute that the overwhelming weight of authority goes the other way, or?
I wouldn't dispute that the majority rule applies something similar to the test that they're applying, but I also am aware of Utah, which is the Norman case, 580 Pacific 2nd 237. So it's not the district companies alone. We may be in the minority, but I really think what answers this question is this court's own cases about attempt, not the cases from other jurisdictions.
And what do you make about Braxton? What do you make of Braxton? Because your opponent's argument, one of the lines of your opponent's argument is that whatever our law has been, if we are in a substantial minority, and the Supreme Court has aligned itself with the majority rule and identified it as coming, rooted in the common law that we're also deriving our authority from, we should resolve the inconsistency in our cases in a way that's consistent with what the Supreme Court has told us to do. What's your reaction to that?
So I don't think that I don't understand them to be arguing, and I wouldn't agree with the principle that the Supreme Court kind of is the last word on the common law within the District of Columbia. I agree it might be persuasive authority if this court were sitting on bonk and deciding what rule to apply in the first instance. But in terms of what the
Just to be
common
clear,
law.
you think the Supreme Court is not the last word on the common law of the District of Columbia? So you think that if we say, you know, we're interpreting as, I mean, this is ultimately, I guess, a statute that is adopts common law principles because it doesn't lay out elements. Clearly, it's a combination of two statutes, I guess, the attempt statute and the manslaughter statute. You're saying that if we interpret those statutes to have certain elements that the Supreme Court would lack authority, as it might with a state court, to countermand that?
I would think so, Your Honor, because otherwise, I'm not sure how different states could have adopted different kind of principles from the common law about what manslaughter and attempt mean.
Well, I guess my implicit in my question is that DC is not a state in all respects, and if the relationship between this court and the Supreme Court is not identical to the relationship between the Supreme Court and state courts.
That's true, although my understanding of the statute providing for the Supreme Court certiorari authority over this court is that decisions of this court will be treated like the decisions of any state highest court. And I think this court has cases talking about how it is kind of the supreme authority on the law of the District of Columbia, and this is a common law question. So I just don't know that the Supreme Court's decision would answer that. I also think that they're relying on a single line from a footnote in a case in which that really was an issue. And so I'm not really sure it really gets them very far, even if you assume that it's kind of more persuasive authority than we think it is. I think this court's cases already address this issue, and this court would be obligated to follow them. I did want to touch a little bit on the factual question about sufficiency, if I could. I agree with your question at the beginning of the argument, Judge McLeese, that the trial court did not find that the first shot was objectively reasonable in some sort of affirmative finding. I think Judge Salerno was really careful in saying, I think there's reasonable doubt about the first shot, so I'm not going to rely on that as my basis for conviction. But by the time we get to the second shot, I don't think there's reasonable doubt. And I think that's very different than what they're kind of characterizing these findings as. I think he's just acknowledging that there's maybe some doubt about the first shot, so it's not really a big delta to the second shot. He could have thought it's more likely than not that the first shot was unreasonable, but it just doesn't get me over the threshold of reasonable doubt.
Can I step back and ask you a standard review question that was discussed to a degree with your opponent, which is, do you agree or disagree with your opponent's contention that once we know, as we do here from the trial court's pretty extensive factual findings, what the trial court's view of the historical facts was, we should review de novo the trial court's determination that the second shot was not objectively reasonable, that we owe no deference to the trial court's kind of reasonableness judgment? Do you agree with that or disagree with that?
I disagree with that. I think the reasonableness finding is a factual finding that would be reviewed for clear error, and Judge Salerno made a clear factual finding about the reasonableness. I think that's the sort of question we would ordinarily put to a jury. You have to find that this shot was unreasonable as part of kind of rejecting the defense that the defense is raising. So I think it would be clear error. I'm not sure there's a huge delta between that and when you're reviewing the sufficiency of the evidence de novo, but viewing all of the facts in light most favorable to the verdict, you still kind of assume that the fact finder credited all of the government's witnesses and drew the inferences in the government's favor. So I'm not sure that it's totally different than, you review this factual finding for clear error.
I think you're right that usually reasonableness is a question of fact for the finder, a fact for the jury. But have we not on occasion said something like, no rational juror could have found that this was reasonable? It's as if there's a range of reasonableness in which the jury's determination controls because it's factual, but at some point in time, we might say that the jury exceeded the bounds of reasonableness. Does that seem like a fair way to describe our case law? As I was struggling with this myself before argument as to what the standard was, and that's kind of what I arrived at as my thinking on this. Is that wrong?
No, I think that's right. And I think that mirrors kind of the standard that you apply for a motion for a judgment of acquittal. You kind of view all the evidence the other direction and you say, could any rational juror reach this conclusion? Similar to kind of a summary judgment standard in a civil case. And I think if you look at the Dorsey case that we cite in our briefs, that was an instance where this court said no rational juror could have found that this was self-defense or defense of others. And so the instruction didn't even need to be given to the jury in the first instance. So I think you're right that at some point, the facts are just so one-sided that no rational juror could have come to a conclusion. I think in this case, there's plenty of evidence supporting Judge Salerno's factual finding about the reasonableness of the second shot. He, went in detail through the shooting and talked about, what LC had, what he was kind of seeing and perceiving at the time. And I think all of that adds up to a very robust body of evidence to support a reasonableness finding. And I don't really take them as pointing out anything that would undermine that finding directly, other than that this occurred in a short period of time. But even the Dorsey case acknowledges that this can be a fast-moving situation, and it's, potentially no rational juror could find that this was self-defense. So I think it's definitely within the province of the fact finder here. So unless the court has any further questions about that issue, we would ask the court to affirm.
All right, thank
Thank
you. Mr. Cronin, you reserved a couple minutes for rebuttal.
So on the plain error issue, this court's precedents squarely foreclose the argument they're making that you have to specifically argue that a particular element is required to preserve that for sufficiency review. We cite GW, which cites the court's en banc decision in Carroll, which expressly addresses this issue. And in Carroll, what the court said, in his initial brief to a division of this court, Mr. Carroll argued that the evidence was insufficient to sustain his conviction because the trial court, the fact finder, was obligated to find that he had uttered the alleged threatening words as a threat. The trial court did not so find, and the evidence did not support your finding. And then they go on to say, as we explained in Newby, it is well settled in this jurisdiction that a full range of challenges to the sufficiency are automatically preserved at a bench trial by a plea of not guilty, and such sufficiency challenges encompass challenges to the requisite elements of the crime. Thus, in Newby, as here, the defendant argued on appeal that the trial court failed to find that she acted with the mens rea necessary to sustain a conviction, and that the record evidence was insufficient to support such a determination. She had not made this claim in the trial court. Nevertheless, we concluded that her argument was preserved for our review because it was in reality a challenge to the sufficiency of the evidence. And they say the same thing is true in Carroll. Now, I also want to just add one little wrinkle to this case that I think makes the Carroll rule all the more applicable here, which is that this claim does not exist until the moment when Judge Salerno says, I find there was that intent to kill was not proven beyond a reasonable doubt, but I'm still convicting you of attempted voluntary manslaughter. And that is the verdict. And I'm not aware of any case that says that a defendant or a respondent in a juvenile case has to say, Judge, Your Honor, I object to your verdict. I mean, if you think the verdict is legally erroneous, you do what you did here, which is file an appeal. And even under the juvenile rules, under the adult rules, Rule 29, Criminal Rule 29, you can renew an MJOA after verdict. The juvenile rules do not have a provision to allow you to renew an MJOA after verdict. So it's not, I'm not saying they couldn't have said, Your Honor, we think you should revisit that ruling, file a motion to reconsider, but it's not required to preserve it. And that's certainly true under GW and Carroll, and it's especially true given sort of the way the issue arises. The government argued that the court's first holding as to the attempt issue is in Ray. As we mentioned in our reply brief, Ray is actually about whether you can be convicted of attempt if the government proves that the offense was actually completed. In some states, an element of attempt is that the crime was not completed. So Ray is saying under DC law, that is not an element of the offense. And I think there is some dicta that says, every proof of the completed crime always means the attempt has been proven, but that is dicta. And I think it's dicta that's wrong, as a number of cases and treatises have said. On the issue of the standard of review, as I mentioned, we cited a case called Gay v. United States in our reply brief. Here's what Gay says. When reviewing a trial court's ruling that a defendant failed to establish that he acted in self-defense, we defer to the trial court's findings of fact unless clearly erroneous, and we review its ultimate legal conclusions de novo. There's a citation to Fersner, and the parenthetical to that citation says, noting that we must accept as true the facts surrounding an assault but that the ultimate ruling as to whether the defendant used excessive force is a matter of law. And also in Williams and in Parker, those are both cases. So in Williams, the trial judge said, I think banging a knife, brandishing a knife and banging it was excessive force. And the court says it was not, as a matter of law. There's no.
Well, for sure, sometimes
Yeah.
we'll say as a matter of law, it isn't if no reasonable fact finder could have viewed it as
Right.
such. So that by itself, I'm not sure it's entirely dispositive.
Right, but Gay is saying this is a
Understood.
question.
I get that, but
Okay.
I have the impression, though I haven't run this to ground yet, that one can conversely find a number of cases that have as their logical structure, sometimes in the self-defense setting, sometimes in others, like Evans, which is about, prompt surrender,
Right.
which said kind of whether something is reasonably prompt or not, ordinarily a jury question. That you can find lots of cases that will be reviewing reasonableness determinations that are implicitly made by juries, and will be saying a reasonable juror could have found this as reasonable, not a reasonable juror could have found facts that as a matter of law, someone would have, that we would de novo
Right.
determine to be reasonable. Now, maybe those are just imprecisions, but it does seem like there is a fair bit of authority that.
I don't even, sorry.
Yeah, no, that's fine.
I don't even think they're imprecisions. I think it just there's this fundamental difference between jury trials and bench trials. And to say reasonableness is a jury issue, I mean, that's like under the Sixth Amendment. The judge doesn't get to decide what's reasonable. That has to be submitted to the jury because that's the defendant's right to have the jury make that determination. And when we have a jury verdict, it's essentially a black box. We say we don't know what facts they found. They might have found there was no subjective belief that deadly force was ever justified. So there's nothing to review. Here we have, in a bench trial, express findings, and the court can make that determination under Gay, saying it's a question of law that is reviewed de novo, and the court can do that. But again, even if you think there's some deference we think the court made legal error in failing to consider LC's subjective perceptions as the prime determinant of his need to use force. The court failed to account for the shots that Officer McGee is firing at the same time that LC, or right before LC fires his second shot. And the trial court erred in assuming that the second shot happened at 7:37, which is contrary to all of the testimony from Mr. McGee and Ms. Braxton, that it was in the same round of fire, that it all happened very quickly. And on page 157 of the November 6th transcript, Ms. Braxton even says 2 shots were fired before Mr. McGee even produced his gun. He says he produces the gun after the 2 shots are fired. So the testimony is flatly inconsistent with the notion that there's this 2-second pause. The video doesn't show the shot being fired. And the fact that Mr. Miles is shot in the back doesn't prove that the shot was fired then, because of all the other shots that were fired that you can see are directly going towards his back when Elsie is running up the stairs.
Can I ask you just to follow up on something that I asked a little bit in your original argument? If we were persuaded, let's say we were not persuaded by your sufficiency points but we had a concern about whether the trial court was applying the right legal standards in some of the respects that you've identified. We discussed that you didn't have an explicit request in your brief in the alternative for a remand for clarification. I think you were hinting that you thought your brief could be construed as implicitly seeking that relief by kind of pointing out some of these concerns that would logically lead to it. But is that an explicit alternative request you would make an argument, or do you really want to stand and fall only with a sufficiency argument?
Well, I think, okay. We certainly have not expressly asked for remand, and I would say the problem with remand is I think the judge has already made the findings. So for example, the finding that LC fired, or McGee fires at LC after the first shot, that can't be revisited, and that establishes by itself that the second shot is reasonable given all the other findings about the first shot being reasonable. So I have a problem with a remand as sort of like in double jeopardy sense. And again, given the judge's finding that the government failed to disprove subjective belief, failed to prove intent to kill, I don't think that it's possible to make that finding that it was objectively unreasonable. But yes, if the court thinks that there's a way to thread the needle between all the trial court's findings, that it could come up with a verdict that the second shot was objectively unreasonable, even though LC is being shot at by Mr. McGee at that point, and even though he believes that deadly force is necessary and hasn't formed an intent to kill, then the court would have to remand as opposed to affirm. Unless the court has further questions, thank you for letting me go over my time.
All right. We thank both counsel for your briefs and arguments today. And at this time, we stand adjourned.